Your Lordship, my application.
Yes.
But I am
My
not
lord,
the official.
The official liquidator and Punjab National Bank has been arrayed to be contemners. My lord, now, my lord, I find that the official liquidator, I cannot quite tell him as a contemner, but the respondent number one. Inasmuch, my lord, we were under the impression that the representation that was to be considered by both the respondents, pursuant to your lordship's order dated 9th of August 2023, which appears at page 21. If your lordship kindly comes, my lord.
Yes.
My lord, at page 22, the relevant portion, my lord, last line, second last line, such representation shall be decided at the earliest by the respondents positively within 1 month from the date of communication of this order to the said respondents. My lord, from records that were misplaced, my lord, and from their affidavit, we find that they have already considered the representation. And my lord, they have also given their reasons as to why they cannot countersign the demand draft, inasmuch as the demand draft was not a part of the sale proceeds which were being made by them. It is admitted that we have not deposited the demand draft within time. My lord, my only grievance today is, way back in 2015, my lord, I had prepared a demand draft for an amount of 22,22,000 through Punjab National Bank. I had wanted the refund back. Punjab National Bank had wanted me to get it countersigned by official liquidator, which the official liquidator, for valid reasons, say that we don't need to countersign because it was not deposited. And by the time when you had prepared the demand draft, the concerned sale was already over. So we do not have any concern with regard to that. My lord, but the Punjab National Bank has ever since, my lord, never been appearing before my lord. Neither had they appeared before your lordship when the writ petition was disposed of. My lord, but they're enjoying the money of 22,22,000 since 2015. So I was only humbly praying, my lord, that your lordship has power to pass an additional and an ancillary order in terms of the order which has been violated. My lord, this representation that I had made, which your lordship was pleased to direct.
We can clarify, Mr. Ghosh, I can clarify if you want that we'll record their submission.
My lord.
Record your submission obviously also, and say that there is no impediment in the Punjab National Bank giving it back to you, refunding it back to you, even without their counter signature.
I'm deeply obliged.
But we'll keep the contempt pending.
Yes, my lord. Or else
that they do it. Yes.
That would, my lord. And if a specific period is, my lord, I'm deeply obliged.
Learned Senior Counsel appearing for the petitioner submits that upon going through you have filed an affidavit in
Yes,
operation?
yes, my lord.
My lord,
It's on record already, you have filed it?
Yes, my lord.
May I file a reply to that, my lord? I'm giving a copy to them.
আচ্ছা তাহলে প্রথম লাইনে করে দিন an affidavit in reply অপোজিশনটা কোথায় এখানে আছে ওকে
The sale was conducted in 2010.
The affidavit in reply filed today by the petitioner be kept on record. Full stop. Learned Senior Counsel appearing for the petitioner submits that upon going through the affidavit in opposition of the alleged container number 1, comma, the official liquidator, and through the materials on record, comma, the petitioner has come to understand that the alleged container number 1 did not have any direct role to play in the alleged violation of the order of this court dated August 9, 2023, comma, whereby both the respondents in the said writ petition had been directed to consider the representation of the petitioner pertaining to the refund of the demand draft submitted by the petitioner. Full stop. Next para. Learned Senior Counsel further submits that it transpires that the stand taken by the alleged container number 1 is valid inasmuch as the official liquidator does not have any role to play or any counter signature to make in the demand draft for the purpose of refund of the same, comma, since the same was never presented to the official liquidator and as well as since the sale in question had taken place previously. Full stop. Next para. Upon hearing learned counsel for learned Senior Counsel for the petitioner as well as learned counsel for the alleged container number 1, who is represented in court today, comma, we find substance in such contention of the petitioner. Full stop. However, comma, we take note of the fact that despite notice, comma, none appears for the alleged container numbers 2 and 3 today at the time of call. Full stop. We take exception to such absence of representation on the part of the alleged container numbers 2 and 3. Full stop. However, comma, at the same time, comma, I make it clear that there is no impediment in the Punjab National Bank to refund the demand draft in favor of the petitioner, comma, in furtherance of the consideration of the representation of the petitioner, comma, which was the crux of the dispute. Full stop. Next para. Accordingly, we direct the alleged container numbers 2 and 3 to ensure that the demand draft submitted by the petitioner, which was the subject matter of the order dated August 9, 2023, in WPO 1469 of 2023, comma, be returned to the petitioner, returned stroke refunded to the petitioner, irrespective of any counter signature being put by the official liquidator. Full stop. It is expected that such return stroke refund shall be completed within a fortnight from the date of communication of this order to the alleged container numbers 2 and 3. Full stop. The alleged container numbers 2 and 3 and all concerned shall act on the written communication of the learned advocate on record for the petitioner, comma, coupled with a server copy of this order, comma, for the purpose of compliance, comma, without insisting upon prior production of a certified copy of this order. Full stop. Next para. The application shall next be listed on May 23, 2025. Full stop. It is made clear that in the event the alleged container numbers 2 and 3 are not present and stroke or represented on the returnable date, comma, appropriate orders may be passed by this court to ensure their presence.
The
I'm deeply obliged.
contaminants number 1 be released, my lord.
Well, I will delete his name.
Yes.
Uh,
And my lord,
yes,
the affidavit in reply to the opposition has been filed.
that we have. The first
Yes.
sentence is that.
Oh,
that
I'm sorry.
affidavit.
I'm sorry. I ought to have been
the
careful.
in view of the above developments, comma, the name of the alleged container number 1 be expunged from the contempt application. Full stop. The learned advocate on record for the petitioner shall accordingly carry out the necessary amendment to the cause title of the contempt application by deleting the name of the alleged container number 1 during the course of the day.
I'm deeply
obliged, my lord.
Ensure that it is done during the
Yes,
course,
yes, we will do that.
not the office, your advocate.
Lord,
Yes, Mr. Chaudhary, what is the contempt?
contempt petition, naturally moving ex parte. I leave it to your
This
lordship.
for the first time.
First time, I want your lordship to just see the order, and then, my lord, I leave it to your lordship whether your lordship wants to issue notice or issue rule. My lord, please come to page 15. My lord, last paragraph. 129 crores has to remain. Award debtors shall be restrained from operating their bank accounts without setting apart the awarded sum of 129 crores. Now, we
Yes.
communicate at page 16 by email.
Right.
At page 18, my lord,
Yes.
I'm not reading the email, my lord. At
You have
page
just set
18,
out.
I went and complained
Ah.
that they're not keeping it apart. So, Lord, please see, my lord, page 18, chief engineer to file an affidavit disclosing mode and manner in which the order has been complied with.
Mhm.
Then, my lord, please see the affidavit at page 60. And this order is also, my lord, communicated. Now, my lord, kindly see page 60.
Mhm.
Very interesting affidavit. My lord, they say that paragraph 5 at page 62
Mhm.
is the order, then page 63. Upon receipt of the order, paragraph 7, same was forwarded to such and such for compliance. Then, the regional officer has asked government to submit a cost estimate. Then, my lord, paragraph 64. Further, my lord, bureaucratic letter sending and receiving. And they say that we have taken steps on a regular basis and steps are being taken to comply. Paragraph 11. It's not complied with. Now, clear contempt, despite notice not complied with. Then, my lord, not only that, they file an application. Application is at page 47. I'm sorry, my lord, praise in the application at 47. Application is starting from page 39. Prayer is to allow extension of time for 1 month to comply with the directions. So, my lord, question today is, if your lordship directs that something has to be kept apart, can, my lord, bureaucratic rigmarole of, my lord, issuing and receiving letters defer the date of the order? Now, having said that, my lord, today we are
This application is still pending.
application
Has
is
been filed on in March, post affidavit of compliance.
Learned senior counsel appearing for the petitioner submits before the court that the alleged contemner, the executive engineer,
no, my
the
lord,
alleged contemners are in gross contempt of the order dated October 3, 2024, passed in EC Com 396 of 2024, inasmuch as in the said order, it was specifically recorded that the award debtors shall remain restrained from operating their bank accounts without setting apart the awarded amount of rupees 129, 01, 14, 018.76p until further orders. Whose of next para, learned senior counsel takes the court through the subsequent developments. First up, the matter came up before a coordinate bench where the learned single judge sitting in such coordinate bench had directed the executive engineer PWD to file an affidavit as to show the manner and mode in which the order was being complied with. First up, in the affidavit filed in response to such order, procedural rigmarole and red tapeism has been highlighted, without any clear intention being expressed as to the compliance of the said order. First up, interestingly, in paragraph number 11 of such application, which is annexed to the present contempt application, it is stated that regular steps are being taken to comply with the directions passed in the subject case. First up, it is more surprising that subsequently an application has been filed, which is now pending, seeking extension of the time by a period of 1 month for compliance of the order dated October 3, 2024. Push up next para. I find from the order in question that there was no question of any stipulation of time limit in the said order to comply with the same. Footstop. By the very nature of the order, it had to be complied instantaneously, semicolon. Otherwise, the very purpose would be defeated if the bank accounts in question were operated without keeping aside the awarded amount as indicated therein. Full stop. Thus, I am of the opinion that a strong prima facie case of contempt of the order dated October 3, 2024, by not setting apart the awarded amount as stipulated therein, has been made out by the petitioner. Full stop. Accordingly, the petitioner shall serve copies of the contempt application on the alleged contemners in order to enable the latter to explain before the court as to the background of, as to the reasons for such non-compliance of the order of this court. Full stop. Affidavit in opposition, if affidavits in opposition to the contempt application, if any, shall be filed within, we are giving them 3 weeks.
Yes, yes.
3 weeks from date, because again, another affidavit will file for extension of within 3 weeks from date, full stop. The reply, if any, shall be filed within June 13, 2025. Full stop. The contempt application shall next be listed on June 20, 2025, when an affidavit of service to that effect shall be filed by the petitioner. Please serve as early as possible.
The problem is not with the learned advocates, my lord.
No.
Or, my lord, with the persons who are doing the work. As my lord, additional
yes.
government period, I face this. The problem is with the law officer of each department.
Yes, you're right.
My lord, the concerned person will tell him do the needful, and he will come to the advocate the night before.
Right. For the first time?
For the first
Yes,
time.
Mr. Pal, what is the matter?
Malad, the content matter, Malad, kindly
Yes.
come to Annex C, Malad. The order dated 18 July, Malad. Malad, by an order dated 18 July, page number 19, Malad. Malad, by an order dated 18 July, Malad has directed the contributory.
Page number? 19 is something else.
Malad, 22, Malad.
Yes, what was the direction?
Malad, there was a direction upon the contributory to pay, Malad, sum of rupees 4,55,000. Malad, immediately, because there was an earlier direction of the coordinate bench, Malad, to pay the sum, said sum, Malad. They have not paid, Malad. By being agreed, Malad, the petitioner has filed an application being CA number 24 of 2026 of 2024, Malad, wherein Malad has a given direction to make payment by the contributor to the petitioner a sum of 4.55 lakhs immediately within a period of 2 weeks from the date of communication. Malad, the said order was communicated on 19th
It
July.
prima facie transpires that a case of contempt has been made out inasmuch as the alleged contemptor. It transpires that a prima facie case of contempt has been made out inasmuch as the alleged contemptor has not paid the amount of rupees 4,45, 000.
Malad,
To the-
55, Malad. 45 they have paid, Malad. 55 is lying due, Malad.
The direction was 445. There was a mistake in the order then, but that was the direction. Very well. The balance amount of specific or darkani. The balance amount due to security agencies stroke applicant as directed in the order dated July 18, 2024 till date. First of next para, accordingly, the petitioner shall serve a copy of the contempt application on the alleged contemptor indicating that the matter shall next be listed on June 20, 2025. Full stop. Affidavit in opposition, if any, shall be filed within 3 weeks. Full stop. Reply, if any, shall be filed by June 13, 2025. An affidavit of service shall be filed on the next returnable date by the petition.
But one thing, Malad, rule can be last talk before the Malad, that's when the Malad was hearing the application, despite of several intimations, they have not appeared, Malad.
Let them do that again. This is contempt. That was not a contempt. ডাকতে তো হবে ফর্মালি এদেরকে পাস ওভার করে পড়তে ছিল for usual passover. Yes, right. Yes, Mr.
And I appear for respondent number 4. The Lordship has been hearing this. We were not invited to the earlier hearing.
I've acquired a habit of hearing this matter. So when this matter will be over, I'll be missing something. You are for respondent of
And
4,
for
right?
the respondent number 4, he's
Right.
the CEO of respondent number 1.
Yes.
He used to own, or he owns 2.23% of the shares. Now, under the SPA, your Lordship knows that it was to be sold. So my first grouse or grievance is that I have not been paid in full yet for my shares. We have transferred the shares in good faith, but because of the share swap, there was a lock-in, so we didn't get the shares. So that I'm told Mr. Bachaut has gone into it threadbare. I will try my best not to repeat. Now, my lord, if my lord just takes section 48 once, so what point I want to make.
Arbitration Act. Thank you. Yes, Mr. Ghosh.
Section 48, my lord. My lord will just allow me to place the 3-4 lines.
Yes.
Enforcement of a foreign award may be refused at the request of the party against whom it's invoked, only if that party furnishes proof to the court proof that C, I'm on C. The award deals with a difference not contemplated by or not falling within the terms of submission to the arbitration. So this is the limb that I want to argue, that one of the decisions regarding damages does not fall within the terms of submission to the arbitration, or it contains decisions beyond the scope of the submission to arbitration, provided that if the decisions on the matter submitted to arbitration can be separated from those not so submitted, that part of the award which contains decisions on matters submitted to the arbitration may be enforced. And just for I am going to rely on this falling within the terms. But just for completion, D also comes vaguely into the same point. The composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. So the agreement of the parties was ICC rules. And in the ICC rules, it provides that issues must be framed. Now, if my lord takes the ICC rules, Article 23, what falls for submission, what are the terms of submission before the ICC tribunals? Article 23, my lord, that's internal page 30 at the bottom.
Yes, please. 20.
I'll just quickly take my lord through the thing. The ones I want to rely on is D and 4. But I'll just read.
Yes.
Terms of reference. As soon as it has received the file from the Secretariat, the arbitral tribunal shall draw up on the basis of documents or in the presence of parties and in the light of their most recent submissions, a document defining its terms of reference. This is the TOR. This document shall include the following particulars: names, addresses, etc. Then summary of case. And D, unless the arbitral tribunal considers it inappropriate, a list of issues to be determined.
So there has to be a recording of inappropriateness if they don't do it.
Yes, but they, in this case, they have made a list of issues. And I want to say this claim for damages, which they have eventually got, is outside the scope of that. There was no such issue for that particular damage that was given. So list of issues. Then my lord will come to, the others are not so relevant, 4. After the terms of reference have been signed or approved by the court, no party shall make new claims which fall outside the limits of the terms of reference, unless it has been authorized to do so by the arbitral tribunal, which shall consider the nature of such new claims, the stage of the arbitration, and other relevant circumstances. I'm saying in this case, they went out, they made a new claim, but it was not formally recorded. After it has been signed, there's nothing in the award to show that they were authorized. That whether the ICC court did it or the tribunal, they simply ignore the terms of reference. So this, yes. So this is absolutely sacrosanct as far as ICC is concerned. So now I will try and demonstrate that the issues that were made did not cover the award that was eventually passed. So for that, I believe, my lord, there is a convenience copy, compilation, volume 2, part B. One second, where's my note?
Got it. Yes. Thank you.
Yes. No, first I'm doing the terms. Page. And there's 2 volume 2s.
Oh.
245, volume 2, part A. I'm sorry, man. A. I'm sorry. Terms of reference. Thank you. What of next? 245 is the terms of reference.
Yes.
This was confirmed, my lord, by the claimant and the arbitral tribunal. And they have signed. That's the award says. We have not signed. At that time, we were not taking part. We had only written a letter challenging the jurisdiction. And eventually, we never took part in this proceeding. But this is that's not disputed. These were the terms of reference. Now, I will come straight later to the issues, which is in paragraph 38 and 41. But before my lord goes there, since I'm just beginning, since it summarizes the case, just for a quick recap, because I know that Mr. Bachawat has taken my lord, but as far as respondent 4 is concerned, if my lord just allows me to quickly take my lord through this TOR once. So first is the parties to the arbitration. 2.4 is relevant for me. I am that party. If the next page, 240.
Yes.
So Gautam Chaudhary is a shareholder of the respondent number one, a company, member of the board of directors and CEO, etc. So that is who I am.
Hmm.
Now, Manoj, then next page, paragraph 5. These were the three, the share purchase agreement out of which the dispute arises. And there were 2 amendments to it. And those are also a part of it. There's no dispute on that. Then, my lord, procedural history, I'm not going into. Your lordship may recall there was an emergency arbitration. Now, that arbitrator in that emergency order had directed the company to hand over certain financial statements. So, one of the issues that came up in the arbitration was, did they comply with this order? And if they did not comply, what was the effect of that? So, that procedural history to that extent is relevant. And before beginning argument, I keep thinking I'll finish in 15 minutes. People have been asking me, but I'm sure it will take some time. But now, my lord, comes to 252. The summary of their case. This is, I want to place this because I'll only need to go into this and a few paragraphs of the award. 26, paragraph 26. The arbitration arises from the respondent's breach of their contractual and statutory obligations. This is very important, my lord. Your lordship will mark their misrepresentations to the claimant of the value of local healthcare when the parties entered into the SPA. Just to spoiler alert, my lord, this misinterpretation was held. There was no misinterpretation ultimately. So this was their cause of action, that they made misrepresentation of the value of their company. And the respondents group A's ongoing failure to comply with the EA order. This is the emergency arbitration order, which led to the deconsolidation of local healthcare's financial statements from UPH, that's the claimant, financial statements. So 2 things that they say. There's first is that there's a breach of their contractual and statutory duties to the extent that, 1, there's a misrepresentation of the value of your company before you entered into it. And 2, because you did not give the financial statements,
Yes.
they could not consolidate it into the the claimant's statements. And in effect, the claimant's statement could not be consolidated in the parent company, that's UpHealth Inc. So they said because this was not done in time and the time statutory periods lapsed, the claim they made in the arbitration was they suffered a loss for this because of this, because that our actions led to a deconsolidation of their financial statements. Now, again, spoiler alert, this was also rejected. These 2 grounds were not accepted by the tribunal itself, but damages have been given still to the tune of, and what they claimed for these 2 breaches, as it were, they claimed $1.7 million. The arbitrators go on to say that this factually there's no misrepresentation, and this deconsolidation is basically misconception because that is the loss of your parent company. So the parent company's loss can't be claimed here. So you haven't really assessed what is your loss because of these 2 factors. And then there was an expert economics professor, I think, or business in finance expert. He had given an opinion supporting what the claimants had made a claim in the SOC, that this was the loss projected for the parent company. So he was asked, then we are lucky that we have the entire transcript of the proceedings. So he was asked by the tribunal that no, you go and reassess this. At the request of the tribunal, and he does in his second report that he gives, which I will be relying on, I'll show your lordship. In the second report, he says, I'm doing this at the request of the tribunal.
That has been placed at length by Mr. Bhatt.
Yes, so that second was given. Len,
Yes.
L-E-H-N. So no, the point I am trying to make, which I think my learned friends have tried to show, my lord, it's against the contract, it's contrary to the thing. What I want to say is this, why was this, how this second report came to be born is basically at the behest of the arbitrators, which shows
That was precisely argued.
there's a bias. No, this bias point wasn't really, I'm told it was not argued in
It was
earnest.
insinuated so much that it became a point.
Hmm?
It was insinuated so much that it became a solid point.
Yes. No, but
By now I am biased probably, unless they dispute.
it is because this gentleman, Mr. Len, says
Yes.
that he covered the damages under 4 heads. One of the heads being that they were not giving appointment in the
He
board.
did a volte-face because he relied on the same documents and then again said
Yes.
that.
And no,
was very-
the first he had taken into consideration what is the effect of them not coming into the board. And that was one of the points, and he came to a conclusion the total loss was $1.7 million. And when he was asked to segregate, he said, if those other losses are not there, he said, it is not possible for me to do so. Then he makes the second report, and just 1/4 of the reasons, 1/4 of the cause, he has given 110. So that is shocking to the conscience of the court. So that part I'm told is argued, but the extra spin that I want to give is that this is also comes under bias and therefore a breach of that I didn't read when I was doing section 48, the explanation 2B of 2B. Now, the enforcement of an arbitral award may be refused if the court finds that the enforcement of the award would be contrary to public policy of India. 2B. And then, my lord, will see what is contrary to public policy. The explanation is given, and Roman numeral 3, it is in conflict with the most basic notions of morality and justice. So beyond the scope of the TOR,
So
and
partial
here-
copy paste of section 34 actually.
34 or actually of the New York Convention also, I think.
That is the internal
Huh?
copy paste of the New York Convention.
And my learned junior gave me a judgment this morning. I'm not showing it because I haven't read it. The Singapore judgment, which talks about a copy paste also.
That was also placed actually.
But that
So
was
Bachchan placed that very with a mischievous smile.
yes. Well, that judgment also the third part of my argument will also in bias will also be that the leading presiding arbitrator in our case. So he basically ignores the terms of reference. And he goes on to adjudicate this new point, this new claim. And then we have found that he's a very famous jurist, Malad, the Mr. Raja, I'm told, and he has written many articles and books. One of his articles says this whole procedure of having a TOR is a waste of time. So that's a what's the confirmation bias, prejudgment. So there is one aspect I'm going to show that also. That his article, that he had this predisposition not to, and for that I'll cite one decision, and for beyond the scope I'll cite one decision. So up to now that is my plan, if I may take my lord through this. But because it's such a lengthy award and there's so many aspects to it, it's interesting. Well, paragraph 26 is, so this was the summary of their claim. Now I'm saying that what I'll argue is both these claims were not allowed, a new claim was allowed. A breach, when the statement of claim they said you have committed, that is in paragraph 27. I'll come to that. So the damages were claimed on these two grounds. Now paragraph 27. When entering into the SPA, the parties envisaged that Glocal would become an indirect subsidiary of UPH, with the claimant having controlling interest and eventually 100% ownership of Glocal with corresponding degree of control over the aspects of Glocal's business. This understanding is reflected in inter alia clause 5.21b3, which requires the respondents to convene a meeting of the Health Glocal's board of directors to appoint claimant's designee as director to the Glocal board. One notable aspect of this control was Glocal's financial statements would be consolidated into those of UpHealth and then UPH, that is the Inc., the UpHealth Inc.
Yes.
So the claimant came to the arbitration with this in mind, that even the breach of 5.2 led to the deconsolidation of these accounts, or they could not consolidate the accounts, and therefore they suffered loss. But what the tribunal says is, because of this breach, they asked the expert to reassess what was be the loss. So now this loss, just to understand, for my understanding, Manoj, initially it was your actions have led me, I have suffered loss because I could not consolidate the statements. And so it is you compensate me for the loss. That's one type of damage. Now, the what damage was given was expectation damage. There are three types of damages. One is the actual loss, which is the compensation you can ask for. That's for restitution, as it were, of your loss. The second part of type of damage is reliance. I relied on you and I spent so much money, which has gone to waste. Now you give me that money. And the third damage is expectation. I expected to make so much money. So what the second report does is that if they came onto the board, they would have fixed all the problems of this company, and they would have implemented a McKinsey report, which is just a consultant's report that these things can be done to improve the company. They would have done that. And then that is...
73, 74 were considered contracted.
I think it's referred, but not...
It was referred somewhere.
It's referred in the transcript. I've seen 73, 74.
Yes, but that...
But it's not discussed as such in the award. They go on to this expectation loss and they give that. And then they say, they temper it and tweak it a bit because this wasn't done, that wasn't done. That guesswork is there. But I'm saying the entire nature of the damages from a compensatory form or the breach, they suffered actual loss, they went into expectation loss, like a loss of profit, etc. That's what we asked. And that is wholly based on this opinion evidence of Professor Len. That also is not like our decisions now is very clear that it has to be on facts. It has to be on the evidence. And this is more hypothetical. Then 28. Had the claimant's designees been appointed as required, it follows that the claimant and its designees of the board would be in a position to exercise control over local contracting, management, contracting, finance, intellectual property, and communications, and would have full access to the information of local. Respondents, however, not only failed to perform their obligation to appoint the claimant's designee to the board, but they actively obstructed the claimants. Again, they are saying that if their claimant's designee came, they would have the materials. Yes. They're not going on how well they would have made, the profits of local would have increased. That was not their case at all when they filed the TOR. Then, in particular, respondents' failure to provide claimant direct access to healthcare's locals' financial statements contributed to UPH being delayed in filing their consolidated financial statements and reports filed with the US Securities and Exchange Commission, SEC, in 3 of the 4 financial quarters ending to this thing. Then, Malad, there's another example of some chartered accountant who gave up trying to get the records from local, allegedly. That's not so important. Then, if my lord comes to 33 is what the EA, because they call it EA, emergency arbitrator, passed this order. This directed that to provide claimant access of all unaudited financial statements, data, and books records necessary to consolidate UPH's 3rd quarter. So their allegation was that because we failed to do so, again, they could not consolidate, therefore their parent had so much loss. Then paragraph 34, that the respondents group A continue to deny access to local financial information. As long as they do so, it is likely that locals' financial statements will remain deconsolidated, causing ongoing harm to the claimant, frustrating the rights of the supermajority, and undermining the entire purpose of the Constitution.
Mr. Ghosh, this emergency arbitration, the effect is equivalent to our interim awards.
It's called an order. It's so equivalent to a section 17, really.
Section 17, really.
Yes. Right. Because I was saying it's not called anywhere an award.
No.
Otherwise, it would have been an interim award.
Exactly. Very well. And the nature of the orders also appear to be in
Yes,
the nature
it
of
says that
17.
you give the statements and then,
Section 17 types.
yes. Then again, 35 says that local had represented that they would meet certain revenue targets. They did not. So this was again a part of this misrepresentation. It will come in that they did not do whatever. And finally, 36, which is a repetition. I'm just reading the second sentence of 36. The situation is further exacerbated by the respondents group's A's refusal to comply with the EA order. So this was the case they came up with. Then the reliefs they sought. Now, my lord will see these reliefs. This is the prayers in the amended statement of claim, paragraph 38.1. 38.1, 2 and 3, they 1 and 2, my lord, they basically asking for a declaration that he is the 94% owner and he has marketable right. Then 38.3, issuing permanent mandatory injunction directing the respondents to convene a meeting like specific performance, etc. None of these are claims for damages. So I'm not reading them.
Oh.
Then my lord will come to then 38.3.6 is to hand over these financial statements. 38.4. 38.4. This
Yes, damages.
ordering Richa, Azim, Richa, Sana, and Chaudhary. Chaudhary is my client,
Chaudhary
and
ji.
Damodaran, to jointly and severally pay damages to the claimant in the amount of the difference between one, the value claimant expected to receive from local healthcare shares it purchased through the SPA based on representations of the respondent such and such before the SPA was signed. So this is on the misrepresentation point. So this is, they want damages because we apparently gave a wrong impression of the value of the shares. Then 2, the value claimant has received from local healthcare shares it purchased through the SPA, the precise amount of damages respondent such and such owe to the claimant will be quantified later in the proceedings, but no less than $150 million. This was their claim on account of the value of the shares that was said to
Difference
be
in the expectation and the actuals.
not expectation. They're saying that we misrepresented to them, we overvalued the
Due
company
to the representation.
before the, yes, before the, but this was the,
expectation based on your representation.
yeah, on my representation, they were induced to enter into the SPA. That's what they are saying. So this is a agreement allegation that you represented it wrong. So this was ultimately held that they haven't proved this. So this is to do with, broadly I'm saying, misrepresentation. Now 38.5, again it mentions damages. Ordering the respondent such and such to jointly and severally pay damages to the claimant in the amount of loss incurred by claimant as a result of the deconsolidation. Now, just your lordship will note this, I'll come to that page, paragraph 372 of the award. These two are rejected, 370, around that. So these two grounds were rejected, and the rest of it, my lord, is costs, etc. So according to them, the claims that they were sought are restricted, damages are restricted to these two. I'm calling it misrepresentation and deconsolidation of the statements. Now, my lord will come to my procedural point 258, paragraph 41, issues. They frame the issues.
So, sorry, please give the page again.
The next page, it's
yes.
258 of the compilation,
Right.
paragraph 41 of the TOR.
41.
Internal page 12. Then it says the following, the consultations with the parties, the following preliminary and non-exhaustive list of issues has been identified for potential determination by the tribunal. The tribunal or parties shall not be deemed to be bound either by this list or the phrasing thereof. So they say it's non-exhaustive, but your lordship has seen Article 23(4). It says that it can only be changed by consent of all the parties and by the approval of the arbitrator. And at least from the award, it doesn't appear that these issues that are made in paragraph 41 sub-paragraphs were changed. So again, now the first three, have the respondents breached such and such clause? Has it breached clause so and so? Have they breached their seller's warranty? And have they breached it? So these are to dealing with what breach did the respondent commit, as it were. No damages are claimed on account of these breaches. That's my point. That now 41.6 and 41.7, these are the two places where there is possibility of a money claim. Did the respondents represent the value of local healthcare when the parties entered into the SPA? If so, did the respondents' misrepresentation cause claimant to pay more than it would have paid to enter into the SPA or otherwise lose value? Was the financial impact, what was the financial impact of those misrepresentations? So here you can say that there is an issue. What was the financial impact of those things? So then the arbitral tribunal has decided that we will come to a monetary finding. But it is based on the misrepresentation prior to the agreement.
Yes.
Now, 41.7, this is with the deconsolidation fact. Did the respondents group A fail to comply with the EA order? If so, did the failure lead to the deconsolidation of local healthcare's financial statements from UPH's financial statements? If so, what is the resulting economic harm to the claimant? So what happens? So these are the two issues which relate to damages.
Yes.
Now, if my lord comes, that is the, then the rest of the TOR is there. Okay. Yeah. So now show me the word. Now, my lord, the applicable procedural law, I don't think I need to place the rest of the TOR. Yes. I'm grateful. Yeah. One more paragraph, my lord. Paragraph 43. The last one, page 259. So
Yes.
here it says it's non-exhaustive, but in 43 it recognizes, subject to Article 23(4), the issues to be determined by the tribunal shall be those resulting from the parties' submissions, including forthcoming submissions. So they reserve the right that they will change this. Now, if you see the clause 4, clause 4 of Article 23, I'm just reading it. Your Lordship, just note that that's there. After TOR has been signed or approved, so this was signed and approved, the one I showed, no party shall make new claims which fall outside the limits of the TOR unless it has been authorized to do so by the tribunal, arbitral tribunal, which shall consider the nature of such new claims and stage the arbitration, the stage of the arbitration and other relevant circumstances. So I'm saying this is not reflected in the award that they were allowed to change the TOR. So if they came with a specific case that they suffered loss on these two accounts, we'll have to see the award now to see whether these two breaches, what amount was given to those two breaches. Now I'll show the award. Okay. Volume compilation, volume 2, part B. Thanks. The award begins, my lord, at 391.
Yes.
And the issues are framed at internal page 17. 407 of this compilation.
Yes.
Those I've read out just now.
Yes, yes.
But it's the same. So 41.6 and 41.7 have not been changed.
So TOR has been quoted.
Yes,
TOR has
the
been
TOR, the issues have been quoted. The other part, that paragraph 38, which I placed, which was their case, which is mentioned in the TOR, that is, of course, not there, but only 41 was there. Then, then, my lord, paragraph 29. I'll do that 372. Just as a summary, my page 410, sorry, 28 and 29.
Yes.
28, the claimants claim arbitration arises from the breach of the contractual statutory obligation. They're misrepresentations to the value of locals, the value of local healthcare when they entered into the SPA. So that's the misrepresentation claim. 29 is for this. And when entering into the SPA, the parties envisaged that local would become an indirect subsidiary of UPH, that's the American company, with the claimant to have a controlling interest and eventually 100% ownership with corresponding degree of control. This understanding is reflected in inter alia 5.2.1b3, which requires the respondent to convene a meeting, appoint the designee as director. Another crucial aspect of this oversight and control was that Glocal's healthcare's financial statements would be consolidated. So again, same cases there in the claim.
Yes.
Misrepresentation and consolidation. Now, paragraph 4. Now, I will come to page. I'm just trying to see if section 73 was, I've marked it somewhere. Anyway, 139 of internal 139, if my lord comes. I'll come back to that.
Yes.
My lord, page
130.
paragraph 313.
Yes.
So this is to do with damages again. Tribunal will address damages arising from this breach in the damages section. Oh, I'm sorry, not that. Next, E.
Yes.
I'll come back to that. This previous part, my lord, which starts at 307. I'll come back to that. I'm just starting from E at the bottom of that page.
Yes.
Ordering respondents jointly and severally to pay damages to UpHealth in the amount of 121 million or such amount as the tribunal may determine to be appropriate, arising from these respondents' misrepresentations. Then what were the misrepresentations? That they would receive the acquisition of the company, the value of what they would receive, and what was the viability of their projects, etc. These were the pre-contract misrepresentations. This part has been decided at 350. Paragraph 350, page 152. That's the conclusion I'm reading, 350.
Yes.
In the circumstances, the claimant has failed to satisfy its burden of proof that Dr. Azim and Kimberlite are liable for misrepresentation. The issue of damages does not arise. So that first point goes totally. They have decided it. It was an issue, they have decided it. Now, after this, could they give damages for a other point? Now, that other thing was page 307. Paragraph. Thank you. My lord will come to paragraph 307, which is at page 525. This was the damages they asked now in the statement of claim as a breach of contract. 525.
Yes.
D. Ordering respondents such and such to jointly and severally pay damages to UpHealth Holding in the amount of USD 1.7 million or such other amounts as may be determined to be appropriate arising from the respondent's breach of contract. Now, there's one point I'm sure it's been argued. I'll show one line of a case maybe, that if a plaintiff has asked for, say, 5 lakhs, even it can be this, or any such amount can be less than 5 lakhs, but it will be limited to 5 lakhs.
Thakkar.
So they want 1.7. Now, 307. The claimant's position is that the respondent prevented the claimant from appointing its designees, as a result of which the claimant was deprived of actual control of the company and suffered damages. Then the claimant argues that, then clause 5.2.1 is set out, then the respondents did not fulfill their obligations. Then, if my lord comes to paragraph 309. Right? This was on the report of Professor Len. Professor Len has calculated the claimant's loss from lack of actual control over the company to be 80 million, the low scenario, 125 million, mid scenario, and 107. This is after the second report. He has come to this conclusion. And they ultimately give 80, I think. Now, 312. Right? The claimant's case is that they suffered loss due to a lack of control and not loss of control, because they never got control. So it's the lack of control. Since they were never, I'm reading 312, my lord, page 529.
Yes.
Since they were never in actual control of the company, this case is compelling. There is no evidence on record to show that the claimant was in control of the company. Rather, the claimant continually relied on Dr. Azim to provide information regarding company and for the purpose of implementing Mackenzie's report. In the circumstances, the tribunal finds that the respondents 2 to 6 failed to give control. The tribunal will will address the damages in the damages section. So this is the finding against me. Misrepresentation was, their claim was rejected. They said, no, you have failed to give them actual control. Then he goes on to damages. Now, damages begins at paragraph 370 something. I'm sorry. No, yes. Internal page 157, paragraph 357. And our page 547.
Yes.
Yeah. So further to the conclusions drawn on the breach and refusal to give control, the tribunal now considers the 3 questions. So they have decided that we committed breach of 5.2, etc. When did the breach or refusal to give control occur? What is the loss of the claimant suffered as a result of breach? How are the damages to be apportioned? Then date of breach. Regarding first issue, the claimant's position was initially unclear. On the one hand, the claimant states that Glocal and its shareholders had failed to provide UpHealth and its and the American company and its auditor with timely, accurate financial information. I'm not reading the rest of it. That is to do with the accounts. On the other hand, the 359, the claimant stated that because of the US requirements in law, I'm just coming straight to 202 of that next page. As a result, UpHealth Inc. publicly announced that it had deconsolidated Local Health's financial statements from those of UpHealth, effective 1st July 2022. And the financial reputational impacts of deconsolidation cannot be overstated. Both these events took place before that fateful meeting. I think that was in September 22, when we voted down and we didn't allow their designees to become. So these 2 events which they relied on was prior to the breach. So then that's what they come to this conclusion, 360. That was the initial case. Subsequently, however, the claimant has clarified its position is that the date of loss is 15th February 2022. This position is problematic. While it appears that the relationship between the parties had significantly soured by Feb 22, there does not appear to have been actual breach by respondents 2 to 6 as on that date. Paragraph 360.
This was called a problematic award by Mr. Thakkaram.
Yes. So no, it is problematic.
Several places problematic has been used also. Problematic has been used in other places.
The description of the award.
Yes, yes.
So, my lord, so then he says, I'm not reading the whole thing.
Need not.
So basically, it's saying that this pleading of theirs was rejected. Now they correct it. That's what I want to show. 362. For avoidance of doubt, the tribunal notes that the claimant's allegations for lack of control relates to actual control of the company and its assets.
61 also the tribunal finds actually that the actual date of
Yes, the breach, that's the date. Yes.
Yes.
Breach was 26th.
Yeah.
Then, now the loss suffered. 363. The next issue is the extent of loss suffered by the claimant.
this actual date of breach was beyond the pleadings also. This actual date of breach,
Yes.
it was beyond the pleadings. The
Yes,
tribunal-
because they have relied on two things. One is
Yes.
that earlier I misrepresented, that was rejected. And the other is that we could not consolidate these statements.
Huh.
And therefore, and that's how Professor Len calculated, it will be apparent from his report,
Yes.
that 1.7 comes because that is the loss that happened to Upheld Think. That's mentioned here, 363.
Yeah.
The next issue is the extent of loss suffered by the claimant. In its amended relief, so this is the last relief they sought. The claimant has claimed a sum of USD 1.7 million or such amount as the tribunal may determine to be appropriate. The sum of 1.7 million was originally claimed as the loss suffered by Upheld Think due to deconsolidation of the company. This was submitted to be the lower bound of damages to be awarded. So in this argument, the counsel had used this phrase. And this phrase is also used by Professor Lai, lower bound. But doesn't mean this is the minimum. They don't say what is but that is not pleaded. It was only, hasn't said that a minimum of 1.7. Nowhere has it been stated. The tribunal raised several questions regarding how the claimant had quantified its claim. In response, the claimant submitted Professor Len's supplemental expert report dated 25th August 2023. The tribunal held a further hearing on 9 September 23 and queried Professor Len on his supplemental report and methodologies he adopted. In the supplemental report, Professor Len reappraised the loss projected revenue of the company due to the lack of control in the range of 80 million to 170 million with the midpoint of 125. Now, the point I'm really trying to make out, all this must have been gone over, is that how did this supplemental report come to be? And for that, I'll show the transcripts. The transcripts.
Yes,
then
Mr. Raja was there. Mr. Raja's
yes,
he asked
him that what is this like? This is not the breach, or this is not the loss of Upheld Holding, or rather the loss of Upheld Think.
He specifically asked that portion of the transcript was probably produced on the last option. You can give the page numbers, but that was placed.
So then again 365 for avoidance of
before that, in response to the tribunal's query whether the damages, that is the second sentence of page 550. That was placed by Mr. Thakur.
I stopped there. Yes.
Response
In
to the
response to the
query.
tribunal's query, whether damages calculations would have been amended if the date of loss is considered to be 26 September, the claimant provided an updated calculation in the appendices A to A3 of the response.
It was argued that this was in response to the tribunal's query.
Yes.
Of itself, it is.
And that in the supplemental report also says at the request of the tribunal I'm doing. Yes. So this updated calculation, we had already stopped appearing, and this updated calculation is given after the supplemental report. First, they asked for the supplemental report, then they asked for a calculation. The re-evaluated damages would be in the range of 70 million to 150 million. Then, for avoidance of doubt, the tribunal notes that the damages sought in paragraph 463.4 of the SOC relates to losses flowing from the lack of actual control. It does not include any damages arising from misrepresentation. So that part goes. This is clearly borne out not only by the wording of the relief in 463.4 and 463.5, but also in the clarification provided by the counsel. So this is where the counsel is quoted to saying that 1.7, I think, is of course lower bound. That's the word has been used. And then the second paragraph of the counsel's quote is to do with misrepresentation. We need not go into that. Then finally, the 366 72 বললাম? হ্যাঁ, পরে দেব। 366. The tribunal finds, this line is very important, the modified basis on which Professor Len has calculated losses suffered to be generally appropriate. Now, there's no change in pleadings, there's no change in evidence, there's not, and the issues or the TOR, and he says that the modified, he admitting it's a modified basis. Len prepared his supplemental report on the basis that if the claimant had been in actual control of the company, it could have implemented the required financial, contracting, legal, and operational controls and made value-enhancing improvements. The tribunal is satisfied that had the respondents observed their obligations, the claimant could have implemented. This is completely hypothetical.
Ifs and yes, hypothesis.
Yes. And the McKenzie report. Len assessed the damages based on the discounted cash flow analysis of the value of the business improvements initiatives recommended by McKenzie, which were not implemented because the respondents alleged breach of contract. Now, the earlier report, he had said this is not an appropriate method. This discounted cash flow method was not appropriate when he was considering what the effect of deconsolidation, etc. was. Then, my lord, I'm not reading Mr. Beck's evidence. If my lord comes straight to page 554, 372. The first part of the page are these are the apparent recommendations given by
Initiatives
McKenzie.
proposed, yes, right.
Not so important, but now 372. In contrast, the claimant's assessment of damages of US 1.7 million being reduction in the share value of UpHealth due to deconsolidation is neither appropriate nor useful. The damages claimed is the loss suffered by UpHealth Inc. and not the claimant. These entities are not one and the same. Further, market conditions where UpHealth Inc. is listed, that is New York, and the previous concerns regarding UpHealth Inc. may not accurately represent the loss suffered by the claimant being deprived of the control of the company. In the circumstances, the tribunal in principle is satisfied with Len's approach to calculation from 26 September. That is the range of 70 million to 150 million. And the midpoint is 110. So they give 110. However, there remains several imponderables in the assessment of damages. Professor Len treats the lack of actual control as permanent lack. So they're saying that he has said as if they will never get back this company. So that had to be tempered. It is unclear why the claimant would have been able to secure additional debt financing. They said that we will get new finances, etc. These things were unclear. And then Professor Len has not carried out a robust but-for analysis on achieving the revenue projections. In these circumstances, relief to be granted has to be tempered, taking into account these considerations. Then, further is discussed. Then I'm coming to the relevant part. Then 383. If I'm missing out anything, you want to show. The tribunal notes 383,558. The tribunal notes in its amended claim, the claimant has sought for, so the last amendment claim was for 1.7 million. Or such other amount as they may determine, as damages arising out of breach. Subsequently, as discussed, the claimant provided Professor Len's 3 estimates of damages arising out from breach of contract. The tribunal is empowered to determine appropriate sum of damages. Claimant has clearly set out its case for loss of actual control arising from the respondent's breach of contract and sufficiently articulated the facts that led to its lack of control over Glocal in its SOC and witness statements. In the tribunal's view, it is plain that the respondents were acting in concert who breached their obligations under the SPA and promptly hand over effective and actual control of the company. So what it's saying is these pleadings were there, so I can pass this damage, that these pleadings that they did not get control of our company. But that really changes. If they knew that, they could have asked for the damages at that time, the
Loss of
appropriate
actual
damages.
control, they had not claimed any damages.
No, they had not claimed.
Their claim was on deconsolidation and the other
Misrepresentation.
misrepresentation.
Yes. Then it goes on to apportion the damages according to our shareholdings, and that is the rest of the award. Now, 2 or 3 things from my prejudice point of view or bias point of view, some of the transcripts. I'll just tell my lord. So just to summarize this aspect which I have submitted, my lord, one is that
Yes.
that no reference was framed to a certain damages for breach of contract. It was misrepresentation and it was deconsolidation, but not for the breach of a particular clause, that is 5.2, lack of control. No damages the issue was framed regarding this. The only 2 damages claims that were envisaged in the TOR was the financial impact of misrepresentation and the economic harm for the failure to consolidate the statements. Then Article 23(4) I'm relying on, that it was never formally amended. And there was no request. Even the final, they've amended their statement of claim twice. Even in the final amendment, they were wanting 1.7. And only the prayers have been amended. The amount was reduced to 1.7. And there was no introduction of new pleadings. Then, my lord, section 48, I've shown, my lord, 48(1)(c). Just, your lordship will make a note. This is the identical to Article 5(1)(c) of the New York Convention. Article Roman V, 5(1)(c), subsection 1, subsection C, of the New York Convention. Identical language.
Right.
The schedule, it's in Schedule 1, the New York Convention is set out. But section 48(1)(c) says, I've placed that. So we are
New York Convention is applicable here. New York Convention is applicable in your case.
Yeah. Though the first point we've taken in my paragraph is that you have to show if your country is, there's a notification that this country,
I was thinking in that lines. I mean,
section 44. Chicago. So I'm assuming New York Convention. I didn't argue this point, but it is.
I don't.
It could have been anywhere. So we've taken the point that they have not produced the note. One of the evidence that they have to produce at the time of filing a enforcement or execution proceeding is that country is applicable. This convention is applicable. So, but I don't think anyone has argued that.
But both of you are relying on New York conventions, probably.
Yes.
Do you disagree?
Now one.
You don't know whether you disagree.
Now, article. It's not there. One page. It's a huge. I'll show it. And the article that I was talking of, Mr. Raja's.
Yes.
That he says that basically that this is TOR is a long-standing feature in the ICC rules for over 100 years. But it's time to change it because now there's new forms of evidence, etc.
His opinion in an article probably is a bit far-fetched. Anyway, you are.
But it just touches on this confirmation bias. So this prejudice was there, so he basically had the predisposition, if I may say, to ignore the TOR.
You're producing that article.
Yes, we have it, but I'm told it's not on record. So I should give it. Leave that.
Probably that is a very weak point of yours. I mean, in articles,
no, it's
It's his opinion in an article. I mean, but
It's a hot topic. Let me put it this way. The predisposition in the mind of the arbitrator
yes,
is that. Now, I want to show the second aspect of this, the terms of reference point, which is that, if I may use the phrase, that it was at the behest of the tribunal, or it was at the encouragement, or the tribunal really prodded or really forced.
prodded has been used by Mr. Thakkar. So
Yes.
you use something.
No, yeah, the note says prodded, but
But that's because the source of the
orchestrated is a better word.
Right. Fair enough.
I heard once, I don't know, I suddenly remembered this morning that your lordship was hearing matters in courtroom number 9, and your lordship told someone it's like humor in uniform. And your lordship said life's like that, but no one in the court understood.
That happens regularly, Mr.
So then, yes.
That happens regularly.
But that's the only thing I can say, is it always happens to me, and I've been told don't stop.
That's the only thing,
But
and
that
that's the
doesn't stop.
lonely thing that happens to you.
So it pays.
That always happens.
I was reminded.
Here
because
we are in much better company. In judges' conferences, all the more so. You won't imagine.
I was going to say that it pays to enrich your word power. That's why that last bit was there.
But the magazine has gone down like anything.
Yes, it's finished.
Seriously,
Yeah.
finished, yes.
But we had the end from 1950 onwards.
Yes,
it was
yes.
hardbound.
Oh,
One of
achha.
my uncle's house. He's
Yes,
got
we also did the same thing because we
covered, and
right,
but
right.
no one reads.
Kept volumes and all.
And Mr. Kapoor had the Punch magazine from
Punch, yeah.
1960 onwards.
Oh,
I asked him many times to give it to me. He said, no, I said, your children will not read it. He said, my children won't, but my grandchildren will.
maybe.
So I hope this being
That's
used.
probably prophetic.
Yes. No? Lost me. This, I wanted to place the transcript. And actually, I had a matter fixed at 10:30 before Justice Sharkar, but I have taken leave till 12. Yes, the Delhi Council has come.
Very
So
well.
I might take another half an hour to 45 minutes. I want to cite 2 decisions.
12:10 I'll be rising, Mr. Ghosh.
And that's why we've said, but
Yes, because 12:30 I have that bench, I will take the break and go to that bench,
very well.
the other bench. But I have given in
No,
my
so
list that
I had thought I'll finish today, but in case I spill over, then only one huge indulgence I'm seeking. 16th, I'm not in town. That's the only other Friday. So either it will be the last day, or if your lordship takes it on a Thursday. Or
day cannot be changed because Justice Kumar's schedule is also my bench partner's schedule is also. It will be very difficult to reschedule the day of the week. I mean,
23rd, I'm there.
23rd will be because this is in the morning. Origin side is in the morning.
Then 23rd will be a change to do something on the last day.
Yes.
Then if your lordship keeps on. So
you can finish. You will not take much time on that date probably.
No, I wanted. I was hesitating to start that now because I have to find out the exact deposition that I want to show, the transcript, that portion, the conversation that took place. How
you can
this
please carry on till 12:10 at least.
I'll carry on.
Touch the other points.
I'll carry.
Because otherwise the others will be in difficulty.
Yes,
to start now.
I'll complete it. Now, just to sum up these points, I want to rely on a decision in the MSK.
Delhi Council will be arguing first there, or you will be arguing?
I am arguing.
Oh.
Horrible point that the power of attorney is invalid. Now the enforcement of foreign award. I'm already arguing. I'm told Justice Sharkar assume that it's Friday, so Mr. Ghosh hasn't come. My reputation is very bad.
So certain things we assume, like Mr. Probal Mukherjee, if we deliberately keep a matter at 10:30 to ensure that he does not come. 10:30, Mr. Mukherjee has not ever come to court. Because I used to park my car during practice near his car. So I used to get the slot.
That's good.
It doesn't come at 10:30.
Well, this is for my learned friend 2011 10 SCC 573. This is that what I was telling my lord about expectation loss, reliance loss. There's a note on this, but that is not why I want to place this. I want to place, my lord, from paragraph 15 onwards. If I may just So, my lord, the facts, it was a normal road contract.
Hmm.
And then the application was made for setting aside the award, which had been allowed. And ultimately, part of it was allowed. But if my lord comes to the for my purposes,
Hmm.
paragraph 15. Oh, I'll start at 13, paragraph 13,
Very good.
which is the finding. We have considered the rival submissions made on behalf of the parties. In the appeal filed by the private contractor, MSK, two issues were involved, namely whether there was a mandatory necessary in the view of the agreement or on the basis of pre-bid understanding that the state had to issue a notification barring the vehicles through the markets of Bharatpur. And secondly, whether the rate of interest could be reduced. So basically, they were making a road, and they said that to recover the cost of the road, they had to make a toll station. So whether, and then the state did not issue some notification, but that's really not important. From 15 to 21, I'll place. The issue regarding the jurisdiction of the arbitral tribunal to decide an issue not referred to it is no more res integra. It is a settled legal proposition that special tribunals like arbitral tribunals and labor courts get jurisdiction to proceed with the case only with the reference made to them. Thus, it is not permissible for such tribunals or authorities to travel beyond the terms of reference. Powers cannot be exercised by the tribunal as to enlarge materially the scope of the reference itself. If the dispute is within the scope of the arbitration clause, it is no part of the province of the court to enter into the merits of the dispute on the issue not referred to it. If the award goes beyond the reference or there is an apparent error on the face of the award, it would certainly be open to the court to interfere with such award. Then, well, this provision is of course under section 34, but this will apply same to 48(1)(c) because the language is the same. Then in Associated Engineering versus Government of Andhra Pradesh, this court held that an umpire or arbitrator cannot widen his jurisdiction by deciding a question not referred to him by the parties. If he exceeded his jurisdiction by doing so, his award would be liable to be set aside. Thus, an arbitrator cannot be allowed to assume jurisdiction over a question which has been referred to him. And similarly, he cannot widen his jurisdiction by holding contrary to the fact that the matter he wants to decide is within the submission of the parties. Then, 17. If the arbitrator commits an error in the construction of the contract, the error is within his jurisdiction. But if he wanders outside the contract and deals with matters not allotted to him, he commits a jurisdictional error. Extrinsic evidence is admissible in such cases because the dispute is not something which arises under or in relation to the contract or dependent on the construction of the contract or is to be determined within the award. The ambiguity of the award can, in such cases, be resolved by admitting extrinsic evidence. The rationale of this rule is that the nature of the dispute is something which has to be determined outside and independent of what appears in the award. If I may stop for a minute, my understanding is that therefore I can give extrinsic evidence. I don't only have to rely on the award to show his bias, etc. So I've shown the TOR, etc. Then such a jurisdictional error needs to be proved by evidence extrinsic to the award. Then several decisions are there. Then 18. In Kishore Kumar Khaitan, this court held that when a court asks itself a wrong question or approaches the question in an improper manner, even if it comes to a finding of fact, the said finding cannot be said to be one rendered within jurisdiction. The failure to render the necessary findings to support its order would be a jurisdictional error liable to correction. Then cellular operators is there. It's just simply put. It posed the wrong question and gave the wrong answer. Then ONGC saw pipes is quoted. Then 21. Last part. Thus, in view of the above, the settled legal proposition emerges to the effect that the arbitral tribunal cannot travel beyond the terms of reference. However, in exceptional circumstances where a party pleads that the demand of another party is beyond the terms of the contract and statutory provisions, the tribunal may examine the terms of the contract as well as the statutory provisions. In the absence of proper pleadings and objections, such a course may not be permissible. Then, my lord, it goes on to the merits of the case and via media orders.
This is more cardinal than going beyond the pleadings, because an arbitral tribunal derives consent jurisdiction. So from
Yes.
the consent.
Yes.
So inherent lack of jurisdiction if you don't submit it for.
Yes.
Rather, more serious goes
No.
into the route more than a civil court going beyond the pleadings,
Yes.
because it derives jurisdiction from that consent only.
And then it just changes the nature of the claim. They had made a specific claim. If they had left it, there's a
Yes.
breach of contract, I have suffered damages like we do in
On a
Section
particular ground.
73.
Yes.
They have specifically named two grounds which
Yes.
have been found to be erroneous.
Right.
And then this supplemental report, I don't know if it's a part of it was handed over to my lord. The supplementary report. ওইটা আমারটা তো পাতলা হবে।
Exhibit.
Oh, yes, this one. No, but since I'm just wrapping up for today, Mala, I'll just cite the other decision that I wanted
Yes,
to
yes,
cite.
better. Yes.
So that the principles, then I have to establish it as far as the, okay, one is this, it will take 1 second, 2006. This is only one line I'll show since Mr. Thakkar has shown this. 2006 SCC online. Oh, you got it. And only the last paragraph. Here it was an ex parte matter. Microsoft had sued someone for breach of copyright. Then, Manoj, the last paragraph will come. And then they gave two experts came and gave evidence. Then they gave examples of damages they have got all over the world, Hong Kong, China, USA, Australia, in millions of dollars. But they got stymied by their own pleadings. Paragraph 30. The plaintiff has produced PW2, who is a chartered accountant who has given the calculation of estimated damages on the basis of the license fee the plaintiff could have earned on the distribution of licensed copies of the software as the defendants had taken license from the plaintiff to sell the software. Damages were quantified in 3 categories: actual damages, damages to goodwill, and exemplary damages. Though on this basis, the total damages worked out to be 1 crore, 28 lakhs, etc. However, in the suit, damages claimed are for 5 lakhs. Therefore, I have no option to limit the claim of the plaintiff to 5 lakhs. Decrease of damages in the sum of 5 lakhs is hereby passed. It's an example of that you cannot go beyond the pleadings of the arbitrator will be more bound than this was a judge. And finally, the other decision that I wanted to cite, this of course is subject to my showing my lord the grounds of prejudice, which have, one is that Mr. Raja's tendency. Yes. And this is unreported case decided on 3rd of July 2023. Microsoft versus ZO AI. So here, it's quite an interesting case. Well, I'll just tell my lord briefly the facts, then I'll come to the plea thing.
Yes.
This, the defendant, the Microsoft owns the domain name of ZO, and which is a AI
Tool sort of.
basically it works on AI. So that's why this person started a domain called ZO AI. So Microsoft sued them. They didn't appear, but it was sent to I think there's the National Internet Exchange of India, NIXI, and they appointed an arbitrator. And though the respondent did not appear, arbitrator went into the facts. He didn't hold a hearing. He gave his own theory and dismissed the claim. Dismissed the claim. But even before the claim was sent to the parties, he put it up on his website. He has a hall of fame that I've been appointed so many times. Again, I've dismissed the claim. So So then this is Justice.
Why don't we get these cases?
This is Justice
It'll take
Pratik
half a
Jalan.
minute, section 34.
I don't know if your lordship remembers him. He's a good friend of ours.
So
He was
Justice
to
Jalan,
practice.
yes. I mean,
Pratik. So my Justice Jalan goes into this and he says that no, he might have dismissed. They argued out of the 29 arbitrations sent to him, 23 had dismissed. He said that's not relevant. But the way he writes in his own website that he takes particular joy in dismissing these applications, and he's made a notched all his victories against the company. He's saying that shows a predisposition. So, but the bias is very well discussed here, and this was, of course, 34, but it was an international arbitration. So they had taken the point, this patent illegality, it will not come under bias. But I'm saying the bias will come under the breach of morality and justice. That last
several. We can find out heads.
Yes, it will
There
come
is bias, we'll find out heads.
because bias is
Public
a normal.
policy of India. Public policy of India.
Yes,
not public policy of India. Because bias, one cannot be judge of one's own cause also. That principle in a roundabout way.
That is natural.
He has a
justice.
cause, he cannot be a judge of it.
So that is one, and here is the more subtle type of bias where a person had the predisposition to
more
decide.
subtle, yes. It's more remote and more subtle.
No, the bias as far as Raja's TOR is concerned, that is very subtle and nuanced. It's that one. I admit that, my lord. But the bias that the tribunal has gone out of its way to correct their claims and bring a whole new claim in violation of the terms of reference, there is an aspect of bias because it has to, is what they say, justice has to be done, not only done, but also seen to be done. There's a corollary that it sometimes has to be seen to be believed that justice is being done. That is only during
I didn't know this.
mentioning.
This is excellent.
For the young people who enter, the mentioning, they just cannot understand what happens on a usual residuary mentioning or something. So that is when I have to say you have to see and then to see it to believe it.
Yes.
Manoj, this decision, Manoj, paragraph 1, just to give the short introduction. By way of the impugned award, the last sentence of paragraph 1.
Yes.
The learned arbitrator has declined the petitioner's claim for transfer of the disputed domain in the name of ZOI by the respondent. So he dismisses their claim. Then paragraph 3, this arbitrator was appointed by the National Internet Exchange of India. I've never heard of this one before, but apparently they have a lot of litigation. Because this gentleman, this Ankur Raheja, was appointed as arbitrator. He himself has done 29 arbitrations. That is
but the same.
No, for the similar, when people challenge other people, has used the domain. Suppose there's a domain, Dhruvo Ghosh. There's a Sarangi player, very famous. He's recently passed away. All the domain names, all the emails, I can never get.
Yes, right.
So,
you'll never get it, yes.
But unfortunately, he has passed. That's what I saw from one of the things. But maybe now. Then, Manoj, so it was ex parte. Now, the submissions, I'm just placing paragraph 6 and 1 or 2 other paragraphs.
Right.
At the outset, Mr. Oshim Sood, learned counsel for the petitioner, accepted that the present tribunal proceedings constitute an international commercial arbitration, as the petitioner is an entity incorporated outside India. He therefore proceeded on the basis that the ground of patent illegality available under section 34(2)(a) is not available. He, however, urged that the following argument in support of his contention that the impugned award is liable to be set aside on the grounds of 34(2).
Oh, the web page was actually named Hall of Fame.
Hall of Fame. So then Mr. Sood submitted that the impugned award is vitiated by bias on part of the learned arbitrator, for which purpose he referred to the web page entitled Hall of Fame on the website of www.indrp.com. Mr. Sood submitted that the aforesaid web page in fact had established and maintained by the learned arbitrator. He drew my attention to the fact that the name of the arbitrator himself appears in the Hall of Fame in the category arbitrators who have denied most INDRP complaints. And then his score is 4. Then, according to Mr. Sood, such comment by the arbitrator shows a distinct predisposition to deny INDRP complaints such as the one made by the petitioner. In support of his submission, Mr. Sood cites the following cases. And then
This can be distinguished because in your case, this is the first instance, maybe.
Hmm?
We don't have a hall of fame. I mean, we don't know.
No, his Hall of Fame is he's written articles
In
that
this-
saying that TOR is a 100-year-old rule. Maybe he has but as long as that rule is there, it has to be followed.
Yes,
Maybe
but
it's
in an
fact-
article, Mr. Ghosh, I may express a view, say, suppose this distinction on monetary, pecuniary jurisdiction of commercial disputes uh, is unfair on people who are come from marginalized sections. That view is expressed in many forums by many judges, including me. But that does not mean when I take up a commercial matter, I'll be biased.
Yes.
I have to follow the law as it
Yes.
is. So that article may be a bit far-fetched.
Yes.
He may have that view, but till it is there, he has to follow.
If you're the third or fourth speaker in the debate, you have to have some points.
Yes, right.
Because the most I'm
Right, right.
trying not to repeat the other points. The fraud is the main thing. That's what I said. The respondent number 4 still date has not got paid for his shares, but he's suffering one thing after another, attachment, decree, award against him.
Yes.
So that thing is the main
Right, right.
peg that we are fighting for. And then I told my learned juniors that we were sold this Mr. Kapoor, of course, taught me, a pig in a poke. That means, and then they said, what is a pig in a poke? So I said, that's a cat in a bag. So they said, there's no cat in the bag. I said, that's exactly why it's called. If you give a sack with a cat in it, you'll find the cat is not there. So we were told, transfer our shares.
Schrodinger is my favorite example.
Yes, that's.
So there is a cat, he's alive and dead. So
You don't know whether
it's observer dependent, Mr. Ghosh. Observer is the judge in this case, unfortunately.
May I come back with
Yes, please, we'll
this
continue
is
with
only on the
Right.
got a good discussion on bias, so I wanted to
We'll
show
continue
those
with
cases
this. Yes, yes.
so that I don't multiply.
We will continue.
But 16th, can it be not clear?
Whenever private, then we'll keep it on
On the
23rd. Let it
23rd.
be on the 23rd. If you're in difficulty, then we'll
Hmm?
consider that.
When-
Let us keep it on 23rd, the last Friday. Let it be on the list of
I am here.
And third in part, on the prayer of learned senior counsel appearing for the respondent, let the matter be adjourned till May 23, 2025 for further hearing.
I'm grateful.
রিভিউটা 16th থাকবে, আমি তো কিছু অর্ডার পাস করিনি, ওই দিন অ্যাডজেন্ট করে review the understanding it will be in the list on the next day because we have not passed in orders, but we'll pass it over on the because otherwise we cannot. আচ্ছা আমি ওটা যদি 10 মিনিটের Yes.
Your Lordship, I appear for the respondent award holder. On the last occasion, Your Lordship directed to file notes.
Yes.
Your Lordship, I'm seeking a week's extension.
For filing notes of arguments.
Yes, we have concluded, Your
What about
Lordship.
you?
We have concluded, my lord, only with regard to the natural justice, my lord, whether the hearing was given to me. I have prepared a short list of dates indicating the dates from the very inception when they have claimed, and they have referred the matter to the MSME, and ultimately matter went
Should you
up.
treat that as your written notes also?
Written notes I have not prepared. I have only to that extent I have prepared, my lord. I can prepare the written notes, my lord.
Prepare and file on the next date.
Yes, my lord.
So we'll keep it next week then. She's asking for 1 week's adjournment.
Yes, sir.
So we're done. Good.
Next week is a holiday, Your Lordship, so then the
Then
week
next
after
Friday week.
Friday.
Right. Friday week. Good. On the prayer of learned counsel, comma, the matter is adjourned till May 16, 2025 for the purpose of filing of written notes of arguments by learned
And
counsel.
also, my lord, we'll make our reply. We shall give our reply.
For the purpose of
Rejoinder.
filing of written notes of arguments by the parties as well as for rejoinder by the
By the petitioner, my lord.
petitioner. This is section 34,
34.
Yes.
In
petition.
connection with the MSME matter. my lord.
Yes. Next.
Item 7, Your Lordship, I'm applying for the petitioner.
Yes.
Mr. Chaudhary has concluded his submission
Yes.
and Mr. Shah was making submission.
Yes.
Mr. Shah is on the way. He'll be coming. But
Will he be coming? Otherwise, we'll.
let us.
We can hear you. No difficulty. You are
Yes, true.
more than competent.
No, not
But not that because there'll be a
conflict. Maybe
conflict. Yes, repetition, conflict, and
probably-
lack of
and probably
continuity.
it may also happen like there may be overlapping in
Overlapping also.
because we had decided yes, he's coming.
Well, you can start.
We'll start.
You can fill in
But
the.
we have covered almost all
Yes.
the two aspects we need to cover today. The first aspect is with regard to the claims, because in respect of the claims, he had some observations which we'll address, and the second part is the legal part. Now, legal part, Mr. Shah is coming and he will take up. Now,
Yes.
so far the claims are concerned, the claims have been categorized by the learned arbitral tribunal in 4 categories. Lordship, if your lordship can come to the claims, I will come to that. But it has been categorized in 4 categories. He says, because the consequence of the incident is the claims. That's the only thing. Once it is decided that the consequence, the cause of the incident is not attributable to the claimant, here the respondent, then he is entitled to claims. Now, leave aside that part. Claims have got 4 categories. Number 1 is the insurance category. Why? He says, whatever claims you can get from the insurance, you get it. I am not allowing you. That's the one part.
Mhm.
The second part of claims are with regard to the actual work done for management of the entire thing, the incident. For management of the incident, there is a second set of claims. The third claim is that some of the loss which has been suffered with regard to the TBM. TBM was cut into pieces, Lordship is well aware of that, and so that is again a loss. And the fourth one, what Lordship he has done, he says that I am allowing you only the cost part, because my learned friend has raised an criticism on that. He has allowed 80%. Why not 60? Why not 70? So the logic is that he has allowed only the prime cost and not the overhead and profit. He is not allowing overhead and profit. So therefore, that is the rationale of 80% of the claims. Now, Lordship, if Lordship kindly comes to the schedule of claims, that is the only thing. It is at para 144, page 322 of petition volume 3. Petition volume 3.
Yes.
This is a summary of claims. The Lordship kindly comes to, there are few categories. Now we are in
category A.
Hmm.
It says he has filling up grout. Lordship has a question on that day. What is grout?
Yes.
Yes. Now that day I had no opportunity to explain it very categorically, but I will take 1 minute to explain what is grout.
Yes.
Now in the soil, Lordship, it is not a chemical compound. It's a mixture of various elements. Lordship, like the soil contains silt, sand, then pebbles, then other elements also. Now it comes in a mixture form. Now when it comes in a mixture form, there may be some void inside it or no void. If there is a void, it is called the dispersibility of the soil. If there is more void, dispersibility of soil will be more. In this case, there was void. So in the void, the water content was there. To remove the void.
Void is like a bubble in between. I mean,
Void, yes, exactly, Lordship. Yes,
gap. Yes.
Gap. Now, if there is a gap, the moment there is a pressure, the
Give way.
leeway. So that is why to consolidate that soil, the requirement of grouting was necessary. Grouting was a cement grouting. There is a chemical grouting also. It goes inside, and the tunnel, the entire perimeter of the tunnel.
So grout is a mixture which is used to fill up those
Lordship, it's a cement or
mortar sort of thing.
Mortar, cement or chemical grouting also. Ashun, Lordship. Let me finish. Can you please come on that aspect of
Your learned friend was grouting.
I was explaining why he is not allowed. So if that is the grout requirement, what the tribunal has held, that grout you are required to do because you have done the soil test, you knew the soil character, you knew that there is a dispersibility of soil. If that is so, you have to do the grout. Now, Lordship, kindly see, he has not allowed for that. Claim number A1, A2. So bulkhead and then grout. He says it's your duty. So he has not allowed. So some claims he has not allowed, group A. Then in group B, he has allowed some and he has not allowed some claims. If you come to page, Lordship comes to page 323, group B.
He starts from B8.
B8.
From
yes, B8. He has not allowed B1. Why he has not allowed? That logic is there. I am not coming to that.
You have not challenged that.
We have not challenged that.
So
Therefore,
yes.
that's clear. So at the end, Lordship, what is there at the page
323, last?
Last I have covered, but he has concluded in his total claim in page, Lordship, page 326. Page 326. Lordship, that is the summary of all claims. Item 22. Lordship.
Right. Yes.
And Lordship, can you see subtotal? We had claimed 115 crore, 9 lakhs, and he has allowed 62 crores, 86 lakhs. So that is a summary of his claims. So, but we have not challenged whatever claim he has not allowed to us. But the fact is, whatever he has allowed, he has given a reason for that. And for reason of 80% has also been explained, as I mentioned to your Lordship. Yeah, 80%, yes, Lordship. I just come to claim number, each of this claim. Hmm. 322, I have already placed it. So at the end, we will cover it in our notes of argument more carefully. So this is the common substance of the claim. Then Mr. Shah will take over, and then finally we'll conclude on this claim part.
Not much time left today. That's why I was wondering. I don't know whether your Lordship has had occasion to peruse the last 5 judge judgment in the matter of modification of award.
Only live law version. Yes, I've seen it, but live law.
Well, I don't know, my lord, whether that will solve any problem or, my lord, add to it.
Add.
Yes.
Because otherwise also, you know
Yes.
why.
I don't know, my lord.
The portion which has been left to us was there, basically.
That was always there.
That was always there.
33, my lord, was always with the arbitrator.
33 was always with the arbitrator.
34-4 was always with the arbitrator.
We have interpreted to segregate also in certain
That's right.
cases.
Your lordship has already, my lord, in earlier matters, segregated awards and, my lord,
Segregated and
set aside
passed,
part,
yes.
my
Set
lord,
aside.
retained part. That has been done. But I don't know what, my lord, is modification, the power to modify award, my lord. What
Modification
is
is something else.
well, all that, yes, that's right. My lord, modification, I would imagine that, my lord, once an award is set aside on the grounds available under Section 34, then the court may modify instead of sending the matter back to
That
the
is
trial.
counterproductive, counterintuitive also. If you
Absolutely.
don't have the power, then it ensues a new de novo arbitration ensues.
That's right.
I mean, or that also not in some cases. So, I mean, I don't know.
Well, if the object of the act is
Object
to,
of the act is
minimize, my lord,
minimize,
litigation,
right?
in
Litigation.
that case, my lord, you cannot drive the parties to a fresh litigation.
Fresh
which may
litigation.
consume, my lord,
Fresh
matters.
litigation.
But I really don't know, my lord, what purpose it has said. It has tried to interpret Kinnori Molik and everything else and said
Yes.
Kinnori Molik
Similar thing happened when Mr. Shah this Section 5 rejection and consequential appeal rejection. That Section 5 rejection previously consistent view of Calcutta High Court was the appeal is non-est in the eye of law, so it's an order. The division is maintainable.
Right.
The moment it was held that no, Section 5 and consequentially the appeal also goes, therefore it's appealable. So if you come up in appeal, the entire consideration in the appeal is only Section 5.
That's right.
And in most cases, Section 5s are allowed and it is remanded back de novo. That appeal has to be heard. And here it is more serious because the purpose of the Arbitration and Conciliation Act is something else.
Exactly, my lord. I was a little, my lord, stumped because, my lord, here, what immediately I'll tell you, lordship, why I, my lord, raised this issue with your lordship. But your lordship has been observing from, my lord, the first day, my lord, that your lordship has been hearing this matter. My lord, my lord, personally, I feel that, my lord, there's one point that has weighed with your lordship, which I have to answer, which I've been trying to answer in my own way. My lord, that point is, my lord, non-consideration of the reports of IIT Madras and, my lord, Shibpur.
Yes.
Now, my lord, so far as non-consideration report is concerned, my lord, in my own way, my lord, I have tried to say already, I shall, my lord, show you lordship a few more paragraphs, that, my lord, no, it is not really non-consideration per se, but it is consideration, but then saying that we shall not, my lord, really, my lord, attribute any evidentiary value to these reports. Well, I have already, my lord, made part submissions on that.
Yes,
if
that be so, it's a discretion of the tribunal,
That's
so
right.
we can't.
Now, my lord, so far as that is concerned, now, my lord, if today, well, it is a matter of non-consideration of, my lord, a particular portion of, my lord, the claims or submissions made by the parties or documents adduced in evidence by the parties. And then, my lord, the matter is before your lordship. Well, lord, now what this 5-judge bench has said that your lordship may suo motu, even without an application, remand the matter back, my lord, for, my lord, removal of those grounds, my lord, which are now, which have caused to the filing of
So
this
Section 33 grounds have been incorporated in the
That's
in
right.
the section.
That's right. Now, that is, my lord, the new feature. Now, my lord, there are two ways of looking at it.
But that is not actually. I mean, 33 is a difficult, I mean, a very limited scenario.
33 is very limited.
Very limited. So we have only that, and it has been clarified in that order. That judgment also probably, if it.
No, this is my 34-4.
Oh, achha.
This is 34-4.
All right.
Number 34-4 gives your lordship the power of remand.
Yes.
Now, my lord, that power of remand is, my lord, exercised for the purpose of, my lord, ultimately allowing the arbitrators an opportunity of removing, my lord, the ground on which a challenge has been brought.
Yes.
Now, my lord, initially, my lord, the view was that that can be only made, my lord, on an application by the parties. But, my lord, now it appears, my lord, on a closer reading of the judgment, I'll, my lord, know that your lordships can also do it suo motu. Now, my lord, the reason why I, my lord, flagged this issue before your lordship is, my lord, today, the non-consideration of the reports of, my lord, IST ship, my lord, that's a Shibpur and, my lord, of Madras. My lord, these have, my lord, been the cause of, my lord, principal cause of challenge. That you have taken some reports into consideration, some reports you have not considered. Now, my lord, so far as the reports are concerned, my lord, your lordship will remember that in this matter, the parties had started adducing oral evidence, but then, my lord, abandoned it. The arbitrator, my lord, said, very well, I shall accept everything into evidence.
Yes.
Well, lord, what therefore remains is considering the evidentiary value of the different reports. Now, my lord, the fact is, my lord, the reports are placed, the reports have not been ignored, the reports have been mentioned. My lord, what is very important is, my lord, the reports have been noticed, referred to, and mentioned. Now, my lord, the question is, my lord, whether the reports have been ignored.
The
Because, my lord,
ground on which it is ignored is more important.
yes. Now, my lord, my lord, law allows an award to be interfered with. Well, if it is based on no evidence at all, well, that is a different matter.
Yes.
Or if it ignores vital evidence. So, my lord, we are now, my lord, trying to paraphrase, my lord, the expression ignoring vital evidence. What would come within the ambit of, my lord, the expression ignores vital evidence? Now, if vital evidence is noticed, but, my lord, the tribunal feels that I have other evidence which I find is more reliable, or, my lord, which I find more acceptable, and, my lord, I therefore do not take this into account, then, my lord, whether ultimately that reflects on, my lord, a probable, my lord, finding. Because, my lord, if today your lordship finds that the arbitrator, my lord, could not have reached this finding by any stretch of imagination, it becomes perverse. It must then shock the conscience of court. But if your lordship is of the opinion that this is a probable view, it's a possible view, then of course your lordships will not ordinarily interfere with it. So, my lord, here, my lord, when your lordship considers, ignores vital evidence, my lord, then, my lord, your lordship will also, my lord, wait in the context of, my lord, whether the view taken was a probable view. Now, my lord, that is, my lord, the question that I was seeking to urge before your lordship, my lord, whether this then was a probable view. Now, my lord, in trying to, my lord, approach this subject, my lord, kindly, my lord, look at it from another perspective.
Somebody's phone has become.
I'm sorry.
No, it's all. Happened to me once.
Sorry, my lord. Kindly forgive me.
No,
I'm taken completely by surprise.
But best wishes all the same.
I don't know, my lord, who it was, but whoever
If it's your birthday, then best wishes. All
yes.
Happy birthday, sir. Yes.
I'm so sorry. No, not my birthday. Certainly not my
Not
birthday.
yours. Oh,
No, no.
we thought-
Well, I do
Then
not
we
know, my lord,
withdraw.
what came on.
Whoever's birthday. We are not bothered.
Now, my lord, here, my lord, the other way of looking at it is, my lord, now, my lord, if your lordship is looking at, my lord, the probable view and the possible view, and, my lord, trying to wait in the context of, my lord, whether evidence has then been ignored. Vital evidence has then been ignored. Now, my lord, your lordship is now, my lord, trying to see that, my lord, if today there is a probable view that the tribunal has reached, upon saying that this is the report that I have before me from, my lord, other authorities or other entities, and ultimately I find that this report is also acceptable, then naturally, if I accept one, I'm not going to accept the other. My lord, please just kindly bear this in mind. Now, my lord, there is a, my lord, bunch of reports, my lord, which were contemporaneous. My lord, which happened at the time of the incident, my lord, when the TBM, my lord, ultimately sunk into the ground.
That is not the reason given by the.
No, my lord, that is, my lord, one part of it. There are, my lord, two parts of it. One, my lord, a set of reports which were available, my lord, with the tribunal at the time of happening of the incident.
Yes.
And, my lord, one is a set of reports which will ultimately placed before the tribunal, my lord, 900 days or later after the, my lord, incident happened, my lord, which is more than 3 years, because, my lord, that is when ultimately the TBM machine was excavated and, my lord, it was broken up in parts and taken. Now, my lord, the observations that have been made there were, my lord, first inquiry was, my lord, what is the cause of the incident? Now, my lord, the cause of the incident, my lord, no one has been able to ascertain with any degree of exactitude. So, my lord, if today the question is the cause of incident has not been ascertained, then, my lord, again, one takes a probable view or a possible view. Now, my lord, in taking this view, what your lordship will find from the award, my lord, is the fact that ultimately, my lord, the equipment itself was chosen with the consent of, my lord, the respondent or the appellant before your lordship, the challenger before your lordship. The equipment was chosen with their, my lord, consent. My lord, their experts, my lord, participate in the selection of the equipment. Number two, my lord, there is an agreement with an expert committee, my lord, which agreement obliges the expert committee to monitor every part of the activity of the contractor. My lord, that is something that has found, my lord, fair amount of reflection in the arbitrator's award. My lord, number three, my lord, the expert committee, my lord, is a committee of experts who have also commented on the incident at the contemporaneous time. Number four, my lord, so far as this is concerned, the question therefore is that in the course of operating the TBM, my lord, did the expert committee at any point of time find out, my lord, anything with regard to, my lord, either, my lord, maneuvering of the equipment wrongfully, or with regard to, my lord, not, my lord, servicing the equipment in a manner suitable to allow it to carry on the work. Now, my lord, there were three, my lord, incidents which were noticed. One is, my lord, with regard to the tail seal brushes. The tail seal brushes were said to be not, my lord, of proper quality. Now, my lord, please, my lord, here, kindly, my lord, bear for a moment two, my lord, aspects of the matter. One is, my lord, so far as the tail seal brushes are concerned, same tail seal brushes used, my lord, for the entire duration of tunneling till the, my lord, machine sank. Same tail seal brushes used for the, my lord, parallel line for which the other TBM was functioning. Number two, my lord, it is on record in this matter that, my lord, there were two replacements of the tail seal brushes immediately, my lord, before this incident, and when this incident happened, it had stopped for a scheduled third change of the tail seal brushes. Now, my lord, these tail seal brushes happened in the front of, my lord, the committee, the experts committee. My lord, the experts committee did not find any fault with the tail seal brushes that were replaced or changed, or the manner of their changing, or, my lord, the process in which, my lord, the change was made, because, my lord, this accompanies the process of greasing. That is, my lord, one of the aspects that has been highlighted before your lordship. So, my lord, two aspects which, my lord, fell for consideration were whether it was adequately greased, or, my lord, whether it was ultimately, my lord, tail seal brushes were of quality. Now, my lord, at no point of time will your lordship find any reflection in either any report or in even letter that the tail seal brushes that you're using are of substandard quality. And my lord, it is the same tail seal brushes that were allowed to be used even subsequently. My lord, secondly, your lordship will not find any reflection, my lord, at the time when, my lord, the tail seal brushes were being changed. My lord, not for, my lord, machine 1, but machine 2 also. Nowhere was it said that no, you're not greasing the tail seal brushes properly. Now, my lord, when it is happens in front of a committee, and the committee, my lord, does not raise any objection, and, my lord, the committee has a duty to supervise these operations, the question is, my lord, whether these two can be, my lord, then cited as incidents which led to the failure. Now, my lord, there is a presumption that accompanies that, my lord, at least these were done properly.
We'll continue on the next.
Yes, yes.
Heard in part for further hearing on May 16, 2025.
Not that it's ছুটি আছে।
9th is a holiday.
16
16?
Yes, ma'am.
Yes.
Lordship mentioning before your Lordship for inclusion in the list.
What?
Review matter.
Yes. Yes. Call on the list.
Much obliged.
Action.
For one for judgment.
Longly shorter, I'm reading out the relevant portions. Accordingly, WPF 4669 of 2023 is allowed in part, thereby striking down the regulation 4.4 of the 2011 tariff regulations framed by the WBRC as ultra-vires on the ground of unconstitutionality and violation of principles of natural justice, as well as contravention of the parent statute under which it is framed, that is the Electricity Act 2003. However, the WBRC will be at liberty to frame appropriate fresh regulations for curbing excess drawals which might jeopardize the grid stability. While doing so, I've given ABCD. The WBRC shall frame specific guidelines and conditions for imposition of restricted drawal by the licensee, if at all such power is conferred on the licensee. Even in such event, the new regulation has to ensure that the restricted limit shall not go below the contracted demand of the particular consumer. Thirdly, at each such instance of restriction of drawal, the licensee must give sufficient notice, at least of 24 hours, to the consumer. Fourthly, the tariff to be imposed has to be governed by specific guidelines proportionate to the damage, if any, caused to the grid based on scientific principles, which may also be assessed subsequently before imposition of such excess penalty. While so assessing, the concerned consumer must be given a right of hearing by the licensee. Alternatively, the WBRC might contemplate formation of a separate body of experts for grid management, which will assess the grid requirements and accordingly assess the damage caused by overdrawal beyond the restricted limit by any particular consumer at a given point of time and calculate the excess charges payable for such violation at each instance proportionate to the damage caused. The WBRC will also be at liberty to formulate regulations if it so deems fit, upon consultation with appropriate experts and giving hearing to all stakeholders, to provide for appropriate measures to protect grid stability if necessary by imposing cut-off limits beyond which no consumer can draw electricity at any given point of time, depending on the particular infrastructure and potential of the concerned grid. However, it will be the incumbent duty of the licensee at any given point of time during subsistence of a contract to supply the contracted demand to the consumer, if necessary, by procuring electricity from other sources within the grid. This is a cue taken from that order of yours. Grid. The licensee, before entering into any power supply agreement, shall assess the grid parameters and capacity for the purpose of fixing contracted demand with consumers. So when you enter into that agreement, you have to ascertain the grid capacity. The new regulations, if framed, shall ensure and specifically provide that at no point of time shall the drawal restriction limit go below the contracted demand in respect of any particular given consumer. In case of imposition of a blanket or general drawal limit restriction being necessary for a specific area, class, or group of consumers, the said limit shall take into account the consumer having the highest contracted demand limit in that area or class or group, which shall be the standard beneath which the limit cannot be imposed. However, insofar as the billing dispute raised by the petitioner herein against the DVC for alleged withdrawal, this court does not enter into the merits of the same, and it is left open to the petitioner to approach the concerned grievance redressal officer or central grievance redressal officer, as the case may be, with such billing dispute. If so approached, the said officer shall decide the issue in accordance with law upon giving adequate opportunity of hearing to all concerned. For such adjudication, the provisions of Regulation 4.4 shall be deemed to have been in existence during the relevant period. It is further clarified that the striking down of Regulation 4.4 by this order shall operate prospectively from this date and shall not affect any bills which may be raised for any billing period prior to this date. In the event the billing period for any consumer is partly exhausted as on this date, additional charges shall be levied only for instances of withdrawal till date and not beyond. The restricted drawal limits already imposed by the DVC and other consumers within the state of West Bengal in terms of the struck down Regulation 4.4, if such restriction is now in force, shall stand rescinded with immediate effect. No order is to cause sudden surrender.
Deeply obliged.
Thank you. একটু বলে দেবেন যে পেজ 19 এ একটা কারেকশন আছে, সেটা যেন দেখে থ্যাংক ইউ ভেরি মাচ।
Deeply.
Your Lordship, I am appearing for CBI. My Lord,
Yes.
may I file the affidavit of service in respect of the intervening application on behalf of the RBI? 467 is it? Original side.
Please, my lord.
Yes.
Siddharth Agarwal, learned senior counsel, my lord. Possibly
Yes.
has joined.
Yes, Mr. Agarwal.
I beg to appear in this fresh matter which your lordships are troubled with today.
Yes, please.
Short issue, issue that arises purely from jurisdiction.
No, no, आपने सीनी
In fact, an issue which lordships have considered in the context of 6 of the Delhi Special Establishment Act. Because would your lordships kind enough straight away to look at your lordships are aware that there was a consent given by the state of West Bengal in terms of section 6, which my lord stands withdrawn, and which I ask your lordships to just look at. Please come to page P53, annexure P20.
That's in item number 4. You also wanted to see item number 4, but the same page, madam. It will be 353.
What is the page number?
353.
353.
Should be volume 3.
Volume 3.
Yes, please. 353.
This is an order of 16th of November 2018.
Right.
In exercise of the powers conferred by Section 6 of the Delhi Special Police Establishment Act, government hereby withdraws the consent accorded by GO number so and so, dated 2nd August 89 of the Home Department Government of West Bengal, to all members of the Delhi Special Police Establishment to exercise the powers and jurisdiction under the said Act in the state of West Bengal.
Right.
Should make kind reference to Section 5 and 6 of the Act.
Have you got a copy of the act?
Yes. I will forward.
It's a short enactment.
Yes.
Just for context, Section 2 is the primary constitution. And it was for all union territories in India.
Yes. There was a judgment of this court, single judge, which was upset by the division bench. I had passed an order whereby it went to the Supreme Court. What happened there? Very well. Let us continue with Ms. Agarwal. Right.
That's Anup Maji's judgment, Pulats. We have it as part of our petition as well.
Very well. Yes.
The lordships had looked at the railways portion of
that area. Yes. The area beyond which consent was given, it cannot. That was upset in appeal, but that is probably before the Supreme Court.
That's right, Pulats. And we are not concerned with that position because there is no railways issue. That was a mining case.
Different, right.
Please come with us to Section 5.
Yes.
Extension of powers and jurisdiction of the special police establishment to other areas. That's other than.
Yes.
The government may by order extend to any area, including railway areas, in a state, not being a union territory, the powers and jurisdiction of the members of the Delhi Special Police Establishment for investigation of any offense or classes of offenses specified in a notification under Section 3. And by an order under subsection 1, powers of the members of the police establishment are extended to such area, because this will become extremely relevant. But thereof, may, subject to any orders which the central government may make in this behalf, discharge the functions of a police officer in that area, and shall, while discharging such functions, be deemed to be a member of the police force of that area, and vested with the powers, functions, and privileges, and be subject to the liabilities of a police officer belonging to that police force. So no doubt the central government can extend it, let us say, to the state of West Bengal. But a CBI officer under Section 5 is so extended, the jurisdiction, the limitations on the exercise of that power will be the same as it belongs to a member of a police force within the state of West Bengal. But now, Section 6. Consent of the state government to exercise such powers and jurisdiction. Nothing contained in Section 5 shall be deemed to enable any member of the Delhi Special Police Establishment to exercise powers and jurisdiction in any area in a state, not being a union territory or railway area, without the consent of the government of that state. So, your lordships are aware, federal structure, and this is the embodiment of that
Yes.
context of a central police force acting within the state confines. With this in mind, my lords, please look at the offending first information report straight away. And I say this, that ex face, it is something which cannot pass muster. Please have annexure P2, page 70. This should be, my lords, in the first one.
Yes. Yes, Mr. Agudu, page 70.
70, my lords. Please
Yes.
have at the top of the page itself, District North 24 Parganas,
Right.
Police Station, CBI BSFB Calcutta. The year, my lords, 2022, the date is 6th of September 2022. So much after the 2018 withdrawal.
Yes.
In
That
the
withdrawal of consent. After that.
That's right. 6th of September 22, this is done. Then see the text of the FIR. I'm not on the merits at the present moment. We are on the issue of jurisdiction. Please, the complaint itself, which begins at 74.
74, right? Yes, 74.
This is a complaint made by the State Bank of India, and please see who it is addressed to. First of all, complaint lodged by so-and-so State Bank of India, Kolkata, Shakespeare Sarani, addressed to the head of branch, Central Bureau of Investigation, Banking Securities Fraud Branch, CGO Complex, Salt Lake City, Kolkata.
Right.
So, complainant, the accused, the investigator, everybody is within the confines of the territories of state of West Bengal. In this context, the investigation, the FIR is registered, and please come to the end of the FIR at page 86. I'm sorry, 85 minutes.
Yes, 85, please.
Just above point number 13. A regular case is accordingly registered and endorsed to so-and-so, Deputy SP, CBI, BSFB, Kolkata for investigation. The original complaint is treated as so. Very evidently, the complaint made by somebody in Calcutta to a authority within the state of West Bengal. Investigation is then entrusted to an officer in terms of exercising his powers at West Bengal. And in this context, what better evidence than the fact that this is, first of all, this is the starting of the or the investigation. But actual investigative steps taken within the state of West Bengal in Kolkata, please have page annexure P21, page 348. This again, Milad, I'm so sorry, I'm taking a lordships between volumes. This is the one.
No, it's all right. I'm sorry, 348 you said.
Yes, that's right.
Right. Yes, I'm there. 348.
This is Milad's in notice dated 28th of June 23. Your lordships will find the address at the top in the head of the page as that of Salt Lake City, Kolkata. The direction to the concerned person is to attend before the officer on 2nd of July at 11 a.m. at Kolkata with certain information and particulars. So please have similarly the next page, 349. This is a search list in respect of a search conducted by the same set of officers within this investigation.
Right.
Again, within the confines of the state of West Bengal. In essence, the submission for your lordship's kind consideration is that given the mandate of section, the withdrawal of consent as of 2018, the very registration of this investigation at Kolkata, the handing over of that investigation to an officer who is at Kolkata, and the exercise of powers is hit by a jurisdiction. This is a void ab initio scenario where the registration of the FIR and every single investigative step, my lords, has to be set aside and set aside.
Yes.
Because now what makes it this, my lords, would have been an error of law, and one which somebody can say that it is something which an officer, my lords, maybe inadvertently, or an agency maybe inadvertently did it. It is still liable to be set aside. But what makes it egregious is the colorable exercise of this power now. And that, my lords, I invite your lordship's attention to page 122, annexure P3. Because before your lordships look at that document, where
Yes.
154 CRPC was the power where the station house officer could register the FIR as the first information. Automatically, under section 157, the objective was that there must always be a ministerial oversight to investigative steps. So within 24 hours, the concerned police station would send that information, my lords, to the magistrate. If your lordships run your eye over
Yes. Yes.
154, 157.
154. Yes. 157 also.
Please, my lords. 154, your lordships will find every information relating to commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reviewed by him or under his direction and be read over to the common. Every such information, whether given in writing, used to writing as aforesaid, shall be signed by the person giving it, and substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. But this is the first information register. And
Right.
So if section 6 had not existed, normally speaking, this officer is duty bound to register a case so long as it discloses a cognizable offense.
And section 5(2) also come into the picture. So
I bow down.
Right,
So,
right.
and he would, I'm most obliged, he would do it in the way
Right.
that officers
Local
are
police. Yes.
most obliged. Now, please come to 156.
Yes.
Police officers' power to investigate.
Right.
Any officer of the police station may, without the magistrate, investigate any cognizable case which a court having jurisdiction, please mark the words, over the local area within the limits of such station would have the power to inquire into or try. So evidently there is a mapping. Colloquially, we may even call it like a ilaka magistrate.
Yes.
Magisterial powers and the powers of a police station are mapped out so that one magistrate has 2 or 3 police stations typically under their jurisdiction, and they are responsible for the flow of information. Now, in this context, please come to 157. Procedure for investigation. If from the information or otherwise, an officer in charge of the police station has reason to suspect the commission of an offense, which he is empowered under 156 to investigate, he shall forthwith send a report to the same to a magistrate empowered to take cognizance of such offense upon a police report, and shall proceed in person and shall depute so and so. But what is essential was the fact 154, 156, 157 in the context of cognizable cases prescribes this mechanism. You receive the information, you record it in your register, you can investigate if your local jurisdiction magistrate has the power to try it or inquire into it, and you will immediately report it to such magistrate. Now please see where the reporting takes place. And this is why, my lords, I said that it is egregious. Please come with me to page 122 of the paper book, volume 1, annexure P3.
Miss out the page number, Mr. Agarwal.
122.
Right.
And your lordships, my lords,
Yes.
I may be so forward to say, it has shocked me, my lords. I've never seen this in my limited career, that FIR registered in the state of West Bengal at Calcutta is reported to a learned magistrate in the state of Orissa. Please come to 122. Form of order. District Khurda in the court of the Special Judge CBI Bhuvaneshwar. Republic of India versus so and so, dated 6 September. FIR for the offense under section so and so from the head of branch CBI BS Calcutta wide letter number so and so, register and put up when final form is received. So what was by itself, the registration of the case, the actions taken, exercising the powers under the CRPC in a state without Section 6 consent, that by itself is round number 1. Colorable exercise of power, which has also been done in order to now create a distance between West Bengal and the action being taken, is the fact that you go and not only you register it here, you're investigating it here, but you now project it and put it in some learned special judges court in Orissa, in absolute defiance to 154, 156, 157. It is on these counts that we seek your Lordship's kind indulgence, and my prayers in the petition are at page 43. And we seek appropriate writ or directions for quashing of this entire matter on the basis of a complete jurisdiction. Because I also invite chiefs to consider a grant of stay in the matter, because evidently there is absolutely no jurisdiction as far as the CBI is concerned in light of 2018 withdrawal. So those are my submissions in opening.
Thank you, sir. Thank you. Anyone else for the other petitioners who wants to supplement anything or supplement anything? No. Very good. Then we'll hear the CBI then? Yes.
Your Lordship, if I get Your Lordship, kindly.
Can you please just address into the microphone so that he can also hear?
Yes. What has been, my Lord, just now shown by the learned senior friend appearing for the petitioner, Your Lordship kindly comes to page 122. Now, this is the
122,
copy of the order sheet. This is the copy. Your Lordship can hear, man.
I can hear.
Yes.
For him to hear, I
I
wanted you to address.
I see.
Yes.
Now, this is the my Lord copy of the order sheet. So, admitted order pending. So, admitted position is that the matter is now pending before the Bhubaneswar special judge. Admitted position. Now,
yes, obviously.
Yes. Now, thereafter, my Lord, I think it is not annex. I have not find, my Lord. There is a search warrant which has also been issued by the same court. I'm just.
We take your word for granted since it's not on
I'm
the
showing,
record.
my Lord, in support of my contention. Your Lordship kindly peruse. Now,
not on the record as yet, so I won't take it. But I'll record your submission that a search warrant has been issued. But
now,
yes,
I accept the proposition that section, my Lord, 6 consent has been withdrawn in 2018 by the state of West Bengal. That is there on record. FIR has been drawn up. But if your Lordship, FIR, complaint FIR, formal FIR. So far the formal, if your Lordship kindly sees, so far the accused number 2's address is concerned. Your Lordship, I'm just referring to the formal FIR, that is page 70.
The same writ petition?
Yes, that is volume 1.
Yes.
WP 7872. Yes, I'm grateful. Your Lordship, kindly.
Right.
Comes to page 72, madam.
Yes, 72.
Now, I stand correct. My page 70, kindly see the place of occurrence. I stand correct. It has been shown by my learned junior and also
place of occurrence.
Senior advocate for the Union of India. Place of occurrence, kindly see.
Yes.
That is column 5. Your Lordship got my lord?
Got it.
Yes. Jharsura unit of Mrs. Concast Steel and Power Limited at Orissa
and 2 other places at West Bengal and 1 place at Andhra Pradesh. Your
Mhm.
Lordship got?
Got it?
Now, Your Lordship kindly take the trouble
Hmm.
to come to page 72.
Yes.
Accused number 2, column 7. Details of known suspected person, unknown person.
Mhm.
Accused number 2.
Yes.
Yes. Now, Prakash Chandra Agarwal. Address kindly see, Your Lordship. Shambhalpur, District Shambhalpur, State Orissa. Director General. So, my lord, occurrence is at Orissa. One of the accused residential address is at Orissa. Now, the complaint, my lord, has been filed before the jurisdictional court. Now, my respectful submission would be before Your Lordship that if there is any grievance, so far the petitioners is concerned regarding quashing of the FIR or non-mandatorability of the FIR, my lord, they are free to go before the Honorable Orissa High Court, not before this Honorable Court. Your Lordship remembers on the earlier occasion also when the matter was heard, my lord, I raised this point, subject to correction from Your Lordship. Now, in support of my contention, my lord, there is 2 distinct things. My lord, FIR has been drawn up, but the complaint has been filed before the jurisdictional court. And it is an admitted fact that the matter is not pending before the Calcutta High Court. With greatest respect, it is pending before the Orissa Special Court, Bhubaneswar Special Court. I stand correct. So any grievance would be agitated, if at all.
They are challenging, they are wanting the quashing of the FIR and everything consequential
Yes,
there.
I'm coming to that.
So FIR was lodged here.
FIR was drawn up here. But my lord, culmination FIR is
FIR was
drawn up here.
Registered here. The
Yes,
FIR.
but thereafter the complaint, my lord.
This what thereafter
yes
means
yes,
that because
yes,
they are
I'm coming
hitting at
to
the
that.
core.
Yes, I'm coming to
The
that.
genesis of it.
Yes, I'm coming to that.
Yes.
Now the point is that whether, my lord, the CBI, so far the bank fraud section is concerned, which Your Lordship is hearing this matter, my lord, can, my lord, file a complaint in other court or not. My lord, in support of my, this point has been already dealt by a honorable coordinate bench of this court. Same issue. I will be placing
Right.
that.
Let us see that.
Your Lordship, I am referring to a circular. My lord will pardon me. I have underlined, my lord. I'm feeling very.
Give a copy to them also.
Yes, I will.
Yes.
My lord, after reading, my lord, I can hand over.
You read out into the microphone and then hand up to me. Read out in the microphone and then
My lord,
hand up.
this is the circular.
Yes.
Dated 3rd October 2020. Jurisdiction of CBI branch units.
Circular issued by?
Circular issued by Central Bureau of Investigation Policy Division, North Block, New Delhi.
Right.
And my lord, subject is jurisdiction of CBI branches units. The jurisdiction of branches and units of CBI are modified from time to time as per the requirements and official exigencies of the organization. The creation of new branches for catering to local requirements and specialized investigation of various types of cases, creation of new states, district, etc. for effectively addressing present needs of the organization, it has become imperative to have a clear consolidated order regarding jurisdiction of the branches or units of CBI so as to rationalize the functioning of organization and making optimal use of the available resources. Accordingly, in supersession of all previous orders, Your Lordship kindly appreciate. Accordingly, in supersession of all previous orders issued on the aforesaid subject, the following shall be organized and jurisdiction of branch stroke units. Now, I am inviting Your Lordship. Now, may I hand over, my lord?
But without a copy to them, we cannot look into a document. You are the CBI. Come on.
No, I understand, my lord. I understand that part, my lord.
Your hands are probably longer than the law.
No, my lord. We are all bowed down to Your Lordship, my lord. Your Lordship is the ultimate authority.
Accepted, gratified, but give another copy.
I have. Now, 58.
Apart from the court, you have got a copy.
No, I'm sorry. I'm sorry, my lord.
No, sir. Thank you, Mr.
I'm paying apology for this.
No, it's all right.
58, my lord.
Yes.
That is BSFC, bank fraud. Now, kindly see the jurisdiction throughout India. Your Lordship got, my lord, column 58.
All right. Throughout India, yes.
সেটা ভাই রিপ্লাইতে বলো, so what? Now, oh, আচ্ছা,
আনিয়েছেন? এটা ধরে দিয়ে দিই। Thank you.
now, in support of my contention, my lord, I am placing the judgments which I have the fortune to appear against Mr. Basu, one of the stalwarts of this court. My lord, this is also I am handing a copy. It is probably unreported. একটা আছে?
Yes.
Yes. Same point. Your Lordship kindly comes to inner pastry, that is, this is Messrs. Fair Deal Suppliers Limited and others versus Central Bureau of Investigation.
Yes.
The same contention was raised. There, my lord, the FIR also drawn up in Kolkata, BSFC, and matter was filed before the Ahmedabad court. Same point was raised by the learned senior counsel, Mr. Basu, as similar to this matter, that it has to be quashed. It was wrongly filed before the Ahmedabad court because CBI intentionally filed the same because consent was withdrawn from the state of West Bengal. Your Lordship kindly comes to paragraph 8(1) or space 3. May I place, my lord?
Yes.
Before parting with Mr. Mitro, has referred to the order dated 3rd October 2020, the same circular. With regard to the jurisdiction of CBI branches stroke units issued by the Central Bureau of Investigation Policy Division 27 such and such has got its jurisdiction throughout Indian, and the complaint was registered before the Court of Special Judge CBI Bhadro, Ahmedabad, Gujarat. The tone and tenor of the revisional application is against the transfer of the case from Calcutta to Ahmedabad, though it was lodged in compliance with the standing order issued by Central Bureau of Investigation Policy Division 27, North Block, New Delhi. Mr. Bose has submitted that the properties in connection with this case are situated in Calcutta. Therefore, registration ought to have made at Calcutta. But I am not agreeable with Mr. Bose as CBI lodged complaint and Ahmedabad within its jurisdiction mentioned in order dated 3rd October 2020 issued by Central
Can
Bureau
the
of
CBI
Investigation.
circular override the law, Mr. Mitro?
My lord, it has been, my lord,
Has been held, we can
yes,
defer.
held. And my lord,
I'll
with
defer.
greatest respect, as my
With greatest
information,
respect, of course, I'll defer.
yes, my my lord, information is concerned, my lord.
Yes, what is your information?
The petitioner in that matter has not challenged this order before the Honorable Supreme Court. So, till date, this order stands good. So far, my respectful submission is concerned. My lord, may I complete, my lord?
Please.
Paragraph 11. I am not agreeable with Mr. Bose as CBI lodged complaint at Ahmedabad within his jurisdiction mentioned in order dated 3rd October 2020 issued by Central Bureau of Investigation such and such. Transfer of case from one state to another. Transfer in view of the matter, I find hardly any merit in the instant revision application which is liable to dismiss without cause such and such. So this has been already, my lord, held by this honorable coordinate bench.
Right.
Just now, your lordship, so far, F আছে একটা রিটে F আছে প্রেয়ারে সুপ্রিম কোর্টের জাজমেন্ট দেখি now so far, my lord, if your lordship, they have served day before yesterday a copy of the, my lord, supplementary affidavit. I think, my lord, if I am correct, that point has not been though taken in the revisional application, has not been urged by the learned senior advocate appearing for them, that the difference of, my lord, Rajesh Agarwal's case, as your lordship remembers, the fraud, civil fraud and criminal fraud, your lordship remembers. My lord, now, my lord, one of the latest judgment, arekta dao copy. Eta arekta copy dao.
Mr. Mitro, before I'll just disturb you for a moment. The situs of the offense was in Kolkata. The location
My
of
lord,
the alleged offense was in Kolkata.
no, it is in Bhubaneswar, as appears from the FIR. As I have pointed to your lordship, my lord, column 5, occurrence, place of occurrence. Place of occurrence is clear, my lord, stated in Jharsuja unit of Messrs. Comcast Steel and Power Limited at Odisha, and 2 other places at West Bengal and 1 place at Andhra Pradesh. So part cause of action is Odisha, part cause of action according to the FIR is West Bengal and also at Andhra Pradesh. So CBI is at free, my lord, to lodge the complaint and the consequent, before
in the
jurisdiction
FIR,
of
I
court.
want to look at the FIR. What was the genesis of this complaint? Then
Yes.
this is the FIR.
Yes. FIR টা
So
কোথায়
what is
আছে
the
দেখো।
nature of the complaint? I
Yes.
mean, on the basis of which
Yes,
this FIR
yes,
was
I'm
written?
coming to that. FIR টা দেখো।
Let us see that. Yes.
In 74, your lordship
74, right?
and sees the addresses over there.
No, have you annexed a copy of that complaint? Do you have a copy of the
Yes,
complaint?
yes, that is the
The
first
complaint on the
annexation.
basis of with which this FIR was lodged.
Yes, so
That is
that
what-
is
So this is the FIR. We don't have.
page
This is the formal FIR, if I stand
Yes.
correct.
I want to see the
The
50,
mother
50.
complaint.
The complaint on the basis of which this was.
50.
Complaint pillage is at page 50, annexure P1.
Yes. Thank you.
Yes,
Thank you.
yes.
And if I can straight away to answer your lordship's query, if your lordships have page 50.
Yes.
Your lordship will see the addresses.
Item 4, time, date and place of occurrence of fraud. The first two bullet points. The accounts of various associates prior to the merger was maintained at our industrial finance branch Kolkata and commercial branch Kolkata. The fraud has taken place at both the aforesaid branches where the accused.
Yes. Yes.
These the addresses which are there in columns.
Seen.
And if your lordship kindly comes to page 74, just now which has been pointed out, my lord, kindly see, my lord, the in the bottom portion, my lord,
Yes.
the address of the address of the director also, Prakash Chandra Agarwal. It is at, my lord, Shambhalpur, state of Orissa. So that is there. Now, apart from this, if your lordship, I am placing এর একটা জাজমেন্টের কপি আছে না আরেকটা ছিল আরেকটা কোন a judgment of the Honorable Supreme Court, Malad Central Bureau of Investigation versus Surendra Patwa and others.
What is that?
Yes. I'm giving that has been your lordship kindly comes to my lord paragraph 9 onwards I'm referring. That was taken by them, this point, though not urged by the learned senior advocate who is addressing for the petitioner, but as because it has been, my lord.
What is the point?
Yes. The high courts have, my lord, the fraud on the basis of Rajesh Agarwal, that opportunity of hearing is required before declaring. That audio.
That's a different point. They have
Yes,
not
that is a
argued
different.
on
If
that.
they are not pressing, but
Right now, at least
been,
they have not argued there.
Anyway, but
We need
here it has been, my lord, to my satisfaction, my lord, it has been already, my lord, decided by the Honorable Supreme Court that when an FIR has been lodged, on that point, it cannot be quashed or set aside. So
FIR cannot be quashed
or set aside on the point of audio alternate pattern. That opportunity of hearing was.
No, that is on a different point.
Yes,
They're
yes,
not
but
taking the audio alternate pattern
no,
at
no, no.
all.
That was taken. That is the reason I. So my.
I for a second I was in a quandary. I thought FIR cannot be quashed.
No, no. Certainly, my lord, there are
The
other
Supreme Court says
parameters.
that we are bound.
My lord, at the very threshold, my lord, I have submitted that FIR can be quashed subject to the jurisdictional court, that is the Honorable High Court at Orissa.
Right.
My lord, that is their forum. So, and your lordship, so far, the FIR is concerned, your lordship, kindly appreciate one thing, that it relates to a huge amount, 27 consortium banks, if I may place before your lordship. FIR.
But the legality does not depend on the magnitude of the offense.
Yes, yes.
At least in this respect,
yes.
Whether CBI had the.
Yes, yes.
So this is your argument.
This is my argument, and another is one prayer. One prayer on the last occasion also, my lord, I want to place before your lordship. Kindly have a look, my lord, of the same writ petition, volume 1, my lord. page 46, prayer F. Subject to correction from my, your lordship, I fail to understand whether this prayer absolutely is maintainable before this court or not. Apart from the point of jurisdiction, which your lordship has been pleased to hear, may I place a writ or writs in the nature of certiorari to issue directing the respondent authorities to transfer the entire records pertaining to FIR number such and such, dated such and such, section such and section such, and commencement of investigation in the said proceeding pending before the learned special judge CBI Bhubaneswar. My lord, my respectful submission before your lordship is that, my lord, this revisional application is absolutely non-maintainable, because if they are aggrieved of the pendency of the point of jurisdiction, that is exclusively the power of the Honorable Supreme Court. High Court cannot, my lord, transfer with greatest respect from one state to another. So it is void ab initio. So this is my respectful submission, my lord, that rightly cause of action, my lord, occurs in the state of Orissa. Accused person's address also is, one of the accused person's address is also Orissa. And though formal FIR has been drawn up in the state of Kolkata, but complaint has been rightly filed before the Orissa High Court. Now, if they are aggrieved, they are free to assail that before the revisional court, before the Orissa High Court. That is my respectful submission.
So we are hearing this for the purpose of ad interim prayers.
Yes,
right.
yes, ad interim.
Now, could I subject to your lordship's
Yes, Mr. Agarwal, if you want to add anything, reply.
two things.
Yes.
Number one, I want to clarify that there is no complaint or charge sheet filed as yet. So my learned friend saying that there is a judicial proceeding pending before any court in Orissa is factually wrong. Matter is at the stage of investigation. We are here to question whether the officers of the CBI, while functioning as officers of the West Bengal Police in terms of Section 5 through that deeming fiction, can actually exercise such powers or not. That is the short issue. The second part, Lords, is your lordships have already noted page 52, the nature of the complaint. I'm beholden to that observation, Lords, of your lordship, is with reference to a fraud that has been committed upon State Bank of India in 2 branches at Calcutta, and that is the substratum of the entire allegation, merely because 2 plants of this company are situated in Orissa or one director is there, is absolutely nothing to do with. The last one was on fair deal, the judgment that has been cited before your lordships. 2 points that I'm making was, one, with utmost respect to the court dealing with that matter, I think there are 2 parts which are not clear. Number one, paragraph 11 indicates that actually the complaint was lodged at Ahmedabad there. And so subject correction. Paragraph 11 indicates that. I can only place that position. The 11 starts with, I am not agreeable as CBI lodged complaint at Ahmedabad within its jurisdiction mentioned so and so.
Yes.
Second, Milord, may I say this with utmost respect, I don't find, Milord, any law or consideration of the legal aspects declared in this judgment, especially in the context of whether, and your lordships have also said it, can a circular internal by the policy division of the CBI override a statutory provision and a requirement for consent in the context of the federal structure? I go back, I'll conclude with only this. Do the officers of the CBI, this is not just the drawing up of the invocation of the person to whom investigation is given is an officer in Kolkata, has caught people in Kolkata, has done searches in Kolkata, and all investigative steps are being taken at Kolkata. That is why, as I said, from the complaint to the registration of the case to the actual exercise of power, everything is contrary to the mandate of Section 6. Those are the submissions.
Just one thing I would like to add, subject to Mr. Agarwal permitting, because I'm for the other party, I needed to show one document. I hope he does not have a problem.
Supporting you, another petition.
I'm supporting.
He won't have any objection, please. Yes. So we're speaking for you. What do you want to add?
51.
What is there? 351, yes. Notice to witness.
Kindly take the last question.
Yes.
Is the last question issued from Kolkata.
একই বলছি।
There are two parts which Mr. Agarwal has already, my learned senior Mr. Agarwal has already indicated. But the factual aspect, which is also extremely pertinent over here, is that the notices continue to be issued from Kolkata. And with greatest respect, as Mr. Agarwal indicated, this particular judgment, which has been referred by my learned friend, does not factor in section 157 at all. Possibly my learned friend appearing from the CBI did not indicate what is the difference between a 154 and 157. He deliberately avoided answering as to how registration is happening in one particular state, and the 157, the follow-up action is happening in 157 in another state. This particular judgment does not deal with that, my lord.
Good.
This is what I wanted to add to Mr. Agarwal's.
Present writ petition has been preferred primarily. Yes. I asked repeatedly, Mr. Lairi, whether anybody has to add anything. You didn't say anything.
But I was
I
waiting.
repeatedly asked.
Submission started.
You was no. Before that, I asked. Before they started, whether anybody. You are for one of the petitioners.
No, Milord.
You are for
de facto complaint.
De facto. Very well. You have a right.
De facto complaint.
Yes, Mr. Lairi.
But I was waiting, Milord.
I'm extremely sorry. Yes, you have a right.
Question is, Milord, the de facto complainant State Bank of India, Milord. Little, Milord. We're back, Milord, to genesis of the proceedings, Milord. These issues will generally.
In fact, do you even have a right of hearing, Mr. Lairi, on this FIR after the FIR is registered? You are the complainant.
De facto complainant.
De facto complainant. So, anyway, we'll hear you because you might have something important to add. Definitely.
Milord, here, I'll come back to this question of de facto complainant later
also,
on.
Yes.
As I was reading, Milord, the petition, Milord, I have been briefed just in the morning by Mr. Pramanik.
Yes.
I was having a quick glance at the petition. Milord, I found that nowhere is there any prayer for quashing the FIR. As your lordship knows, Milord, quashing of the FIR is, Milord, as the case law is enunciated in the earlier days in the case of Sanchita, taking the allegations in the FIR to be true on the basis that they are true, assuming they are true, no complaint is made out. Then the FIR can be quashed. Here, Milord, really, what they are, Milord, agitating here in this petition, subject to correction, is, Milord, their entire attack is directed against, Milord, the proceeding pending with the special judge Bhubaneswar. When heard my learned friend saying that nothing has been done to the special judge Bhubaneswar, it is only at the stage of FIR, not so. Milord, on their own showing, the special judge Bhubaneswar, Milord, now in ceasing of the proceedings. And really speaking, they are, Milord, assailing the jurisdiction of the special judge Bhubaneswar in this writ petition. Now, before your lordship, Milord, a judgment has been, Milord, shown by me learned friend pair with the CBI. Milord, there's a judgment by coordinate bench. Milord, under similar circumstances, instead of Ahmedabad, Milord, it's now Bhubaneswar. But under similar circumstances, I believe, Milord, the FIR was here and Milord, ultimate complaint was lodged in Ahmedabad. Now, Milord, lordship knows, Milord, deepest respect to lordship, Milord. Lordship, Milord, is inclined to, Milord, differ with the finding of another coordinate bench.
I have to refer.
Lordship will kindly consider the question of.
Yes, yes. Unless there is a distinction, I hold that there is a distinction in fact or otherwise.
Yes.
Definitely, if I don't agree with the proposition, if a precedent is laid down, definitely, Mr. Lairi, the coordinate bench cannot differ. It's binding on me also. I have to refer it. But if I refer, you know what will happen to the stay prayer.
Milord, we refer to this.
So, I'm trying to avoid a reference because I'll give my reasons why.
Yes. Now,
for the present.
With reference to the prayer for stay.
I'll give my reasons why I need not, disagree with this judgment at this stage. This is a prima facie consideration.
That is so, Milord. Now, lordship has not pronounced anything. But when the little experience that I have at the bar, Milord, I can definitely read what is passing through lordship's mind.
If after what I said you cannot read, Mr. Lairi, you need not be a senior for that.
You'll have to wait till the end.
No, absolutely. I've not passed my order as yet. My mind is still really open. I mean, you can change my mind.
Now, my question is, my lord, now, as I was telling your lordship, my lord, this realist, my lord, goes to the, my lord, challenging the proceedings with Special Judge Bhubaneswar. Lordship will envisage the situation whether they have got a viable alternative remedy rather
I'm
than
sorry, viable?
alternative remedy. Because really, the challenge is now, my lord, directed at pendency of a criminal proceedings. Instituted rightly or wrong.
Yes.
Well, I am not the question of forum. Maybe the right forum, maybe the wrong forum. Because they are not really, my lord, on the question of quashing of the FIR. Lordship looks at the prayer, my lord. They don't say that the FIR should be quashed. They say, my lord, really speaking, that I'll be prevented from, CBI will be prevented from proceeding with the case pending before the Special Judge Bhubaneswar. This is a restraint order on the prosecutor from proceeding with the case before the Land Special Judge Bhubaneswar. Why? Because according to them, Special Judge Bhubaneswar would not have taken cognizance of the matter, or it's the basis of a FIR which is defective according to them, because Section 6 is applicable to the facts of this case. Now, the question before your lordship is, my lord, if I am allowed to argue this, take this point at the very initial stage, whether my lord lordship knows, my lord, this pendency of proceedings before a criminal court, my lord, or otherwise, my lord, the jurisdiction of the criminal court can be challenged in appropriate proceedings, my lord, by filing a civil divisional application.
Has the jurisdiction of a criminal court as yet arisen? Because the charge sheet has not been filed, Mr. Lahiri. So the jurisdiction of the court has not yet come up even. So you know better that unless a charge sheet is filed, the jurisdiction of the court cannot be invoked at this stage. As a court, I mean. All say no, all say no. All of them say no.
Gives me a minute.
Very well.
Has been issued.
Because I was trying to inquire whether the magistrate has taken cognizance of the case.
Not yet. Okay. That is a specific point taken by the petition, that it has not yet been taken. If that was so, then Mr. Lahiri would have a very good point there.
Investigation has been done. Search warrant has been issued right now by the Bhubaneswar Special Judge.
Still investigating officer.
You filed the report 173 crores. In the process of being prepared. Anyway, look, the 173 proceedings, the charge sheet is yet to be filed. So, my lord, appearing for the, my lord, the first of all, first question will be, my lord, the de facto complainant, the State Bank of India, has not been made a party, and only an officer of the State Bank of India, my lord, Deputy General Manager, who was merely, my lord, acting as the agent of the principal State Bank of India.
Yes, as a complainant.
So, therefore, if this, my lord, the order that is being sought before your lordship, if there is the effect of affecting the interest of State Bank of India and other banks of the consortium, lordship will kindly consider before passing any interim order whether, my lord, those, my lord,
the officer has been implicated in his personal capacity here. Let us just check up.
Personal capacity by name.
Just check up which
Deputy General Manager given the designation.
In his capacity, in the capacity in which he lodged the complaint, in that capacity has been mentioned.
If that capacity is mentioned,
the bank was not the complainant by itself. It was this person acting as Deputy General Manager of the State Bank, which was the complainant.
Bank has to lodge a complaint through an officer whom the bank authorizes.
Yes.
So he was really acting as the agent of the principal State Bank of India. So he is not personally affected by the results of these proceedings. It is the State Bank of India. But the State Bank of India and the other banks for the matter have not been made a party here. So whether any order that may be passed by lordship, that will kindly consider whether, my lord, it behoves the petitioner to completely oust, my lord, the other interested parties while seeking an interim order before a lordship.
Enforcement Director.
ED not. ED has already come into the picture, my lord.
ED.
But anyway, that's a different matter. That's neither here nor there.
For the present, let us deal with CBI first, then we'll go to
Yes, yes. For the deal with CBI and the absence of State Bank of India.
Yes, yes, definitely.
Which is really the affected party. Right. So, well, these are my submissions for the time being, Lord.
On this is at the ad interim stage.
At the ad interim stage, right.
The present challenge has been preferred in respect of initiation and continuation of investigation against the petitioner. Should we club all the writ petitions together? The other facts are similar.
Same regard to the original side matters, I am appearing soon. In those matters, not only the LOC has been challenged in one of the matters, and another is respect to the fraud. So, my lord, kindly, my lord, detect those original side matters.
So, very well, we'll take up the those applications. This is only for the appellate side matters. Then I'm first passing this order. Then yes, there may be common grounds, but we'll.
Yes. Millet, one other point, Millet, I missed.
The appellate side order. Yes, Mr.
One very small point, but that's
yes, please make it. Yes,
as we pointed out by my learned friend for the CBI, that Millet, the place of occurrence was shown to be Milord Jharsuguda in Odisha.
No, he placed that point. He made that point.
Now,
page 122.
Now, my learned friend from the petitioner Milord has shown
yes
that as per the Milord the complaint, the fraud has taken place in 2 addresses in Calcutta, in West Bengal. But the question is, Milord, apart from the question of fraud, Milord, allegations of under other sections of the IPC is also there. It's not only the question of fraud, Milord. Not fraud is not the Milord only and the sole allegation against the petitioner. Lordship looks at the Milord the complaint, Milord. The other sections are quoted there, and Milord the FIR shows that the place of occurrence is in Jharsuguda. So it remains to be investigated as to which part of the alleged offense taken which place. If it is found that some offense was committed in Jharsuguda, Milord, obviously then, Milord, the trial seeking of initiation of trial before the magistrate in Odisha will be competent for the CBI.
Yes. Now we'll continue with my order. Yes. Kothay challam? Continuation of investigation against the petitioners in all these matters. It should be appellate side. In connection with FIR number caps RCBSK 2022 capital E 0001 dated September 06, 2022 under sections 120 capital B stroke 420 stroke 477 capital A of the Indian Penal Code 1860 and sections 13 within bracket 2 and 13 within bracket 1 within bracket small d of the Prevention of Corruption Act 1988 and commencement of investigation in the said proceeding pending before the court of the learned special judge within bracket CBI hyphen Roman 1 bracket closed comma Bhubaneswar as RC case number 01 within bracket cap E bracket close of 2022 and consequential reliefs. Push up next para. Learned senior counsel appearing for the petitioner's contents that in contravention that the present investigation is going on at the behest of the CBI within bracket Central Bureau of Investigation in contravention of the provisions of sections 5 within bracket 2 read in conjunction with section 6 of the Delhi Special Police Establishment Act, 1946 within bracket for short the 1946 Act. Bracket close, push up. It is pointed out that in terms of section 6 of the said Act, nothing contained in section 5 thereof shall be deemed to enable any member of the Delhi Special Police Establishment within bracket DPSE bracket closed to exercise powers and jurisdiction in any area in a state, not being a union territory or railway area, without the consent of the government of that state. Full up next para. On the other hand, section 5 stipulates that the central government may, by order, extend to any area within bracket including railway areas bracket closed in a state, comma, not being a union territory, comma, the powers and jurisdiction of members of the DPSE for the investigation of any offences or classes of offences specified in a notification under Section 3 of the said Act. Full stop. Next para. Subsection 3 thereof, comma, it is contended, comma, provides that where any such order under subsection 1 is made in relation to any area, comma, then, comma, without prejudice to the provisions of subsection 2, comma, any member of the DPSE of or above the rank of sub-inspector may, comma, subject to any orders which the central government may make in this behalf, comma, তারপর italics-এ exercise the powers of the officer in charge of a police station in that area, আবার normal, not italics, and when so exercising such powers, our italics, shall be deemed to be an officer in charge of a police station discharging the functions of such an officer within the limits of his station. Italics is full stop. Next para, learned senior counsel submits that by a notification dated November 16, 2018, vide number 450 stroke cap HS stroke cap PA stroke 18, comma, the government of West Bengal withdrew its consent as accorded within the contemplation of Section 6 of the 1946 Act to all members of the DPSC to exercise the powers and jurisdiction under the 1946 Act in the state of West Bengal. Push up. Next para. Learned senior counsel points out that the genesis of the impugned FIR within bracket first information report, comma, was a complaint lodged by the respondent number 4, comma, the Deputy General Manager of the State Bank of India, comma, SAMV hyphen Roman 1, comma, Kolkata, full stop. Next para. Thus, comma, since the complaint was lodged in Kolkata pertaining to an offence allegedly committed in Kolkata, comma, which falls within the state of West Bengal, comma, in the teeth of the withdrawal of such consent under Section 6 of the 1946 Act by the said state, comma, the entire investigation and initiation of proceedings within the state of West Bengal by the CBI is bad in law. Full stop. Next para. Learned senior counsel next contends that, comma, not stopping there, comma, the exercise carried out by the CBI in continuing the investigation borders on the egregious, comma, amounting to a colorable exercise of its so-called powers. Full stop. It is contended that in terms of Section 5 within bracket 2 of the 1946 Act, comma, the officer in charge of the investigation is deemed to be an officer in charge of a police station discharging the functions of such an officer within the limits of his station. Full stop. Next para. By placing reliance on sections 154, 156 and 157 of the Code of Criminal Procedure, 1973, which is applicable in view of the date of the lodging of the complaint, learned senior counsel argues that none of the said provisions have been complied with. Full stop. With special reference to Section 157 within bracket 1, it is contended that if from information received or otherwise, an officer in charge of a police station has a reason to suspect the commission of an offense which he is empowered under Section 156 to investigate, he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offense upon a police report, and shall proceed in person or shall depute one of his subordinate officers not below the rank as specified therein, to proceed to the spot to investigate the facts and circumstances of the case and take necessary measures. Push up next para. Under section 156 within bracket 1, comma, any officer in charge of a police station may, comma, without the order of a magistrate, comma, investigate any cognizable case in which, bucket italic say, a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter Roman 13. Full stop next para. It is submitted by learned senior counsel appearing for the petitioners that in stark contravention of the same, comma, although the complaint was lodged and the FIR registered in the state of West Bengal, comma, the report was filed, comma, surprisingly, what was the page number of that?
Page 122 minutes, annexure P3.
122. Thank you so much. Surprisingly, comma, before the court of the special judge within bracket CBI hyphen Roman 1 bracket close, comma, Bhubaneswar. Full stop next para. It is thus argued as the second prong of attack in the present writ petition that even if it were to be construed that the CBI had the jurisdiction to conduct the investigation, comma, the status of the investigating officer would be that of an officer of a member of the local police force, and as such, comma, the provisions of sections 154 to 157 of the Code of Criminal Procedure would apply. Full stop. Since there has also been violation of the said provisions as indicated above, comma, it is argued that the entire procedure of investigation is vitiated and ought to be set aside, stroke stayed. Full stop. Next para. It is further pointed out by learned senior counsel appearing for the petitioners in the respective cases that the complaint was lodged in respect of an alleged offense which was purportedly committed within the state of West Bengal, and as such, comma, the scope of any investigation being carried out beyond the jurisdictional court, comma, in a different state, comma, in this case Odisha, comma, is also dehorsed the law. Push up next para. Learned counsel appearing for the CBI contends, comma, while opposing the arguments of the petitioners that in the present case, comma, search warrant has also been issued in terms of the FIR. Full stop that apart, comma, pointing to the relevant portion of the FIR annexed at page 70 of the present present writ petitions, comma, it is pointed out that the place of occurrence has been mentioned as Jharsuguda unit of the concerned company at Odisha, and two other places at West Bengal and one place at Andhra Pradesh. Push up, hence, comma, since a part of the cause of action also pertains to Odisha, comma, it is submitted that the continuance of investigation is in Odisha cannot be prevented by this court. Full stop that apart, comma, it is argued that since the offense is of a multifarious nature, comma, covering several states, comma, the bar under section 6 of the 1946 Act, comma, in view of the withdrawal of consent by the state of West Bengal, comma, is not applicable in terms in the present case. Full stop, it is further pointed out that the second accused in the present case has his address at Odisha, and that the office of the company in question is also situated in the state of Odisha. Push up next para. Apart from the above contentions, comma, the CBI challenges the territorial jurisdiction of this court to take up the matter, since in effect, comma, it is contended, comma, the present challenge has been preferred against an ongoing investigation by the CBI court in the state of Odisha, and as such, a challenge under Article 226 of the Constitution of India ought to have been preferred before the Odisha High Court. Full stop. Next para. It is further argued that in terms of a circular issued by the CBI on October 3, 2020, the jurisdiction of the CBI branches and units have been delineated. Full stop. The present investigation, it is contended, is going on in terms of the said delineation and cannot be said to be vitiated in law in any manner. Full stop. Learned counsel appearing for the CBI places reliance on an unreported judgment of a coordinate bench of this court in the matter of CRR 2634 of 2023, bracketed namta diye diye, Messrs. Fair Deal such and such, in support of the contention that in a similar case, the learned single judge in the said case had refused to transfer the case from a different state within bracket in the said case Gujarat bracket closed to the state of West Bengal. Full stop. It was observed there, on the basis of the circular dated October 3, 2020, with regard to the jurisdiction of CBI branches, that the EOB, Kolkata branch has got its jurisdiction throughout India, and the complaint was registered before the Court of Special Judge of CBI, Bhadra, Ahmedabad, Gujarat. Full stop. It was further held that the tone and tenor of the revisional application before the said court was against the transfer of the case from Calcutta to Ahmedabad, though it was lodged in compliance with the standing order issued by the CBI. Full stop. On such ground, the learned judge refused to transfer such case. Full stop. Next para. Upon a careful consideration of the materials on before this court, as well as the arekta line add kore daw. Learned senior counsel appearing on behalf of the de facto complainant argues that the writ petitions are bad for non-joinder of the State Bank of India and the other banks which were a part of the consortium, who had in effect, through the Deputy General Manager of the State Bank of India, acting as an agent of the State Bank, lodged the complaint. Full stop. Next para. Furthermore, it is added by learned senior counsel for the de facto complainant that prayer C made in the prayer C made in the writ petition is not maintainable in the eye of law. Full stop. Next para. Upon hearing learned counsel for the parties and perusing the materials before the court, I find a strong prima facie case for hearing the writ petition on merits having been made out. Full stop. Next para. Insofar as the territorial jurisdiction of the CBI is concerned, at the outset, it may be noted that the internal circular stroke order dated October 3, 2020, issued by the Policy Division of the Central Bureau of Investigation within bracket CBI, that too merely for the purpose of laying down the organization and jurisdiction of its respective branches stroke units, cannot override the law as it stands. Full stop. Next para. At best, the said order is binding on the officers of the CBI internally and does not hit at the root of the jurisdiction of the CBI, nor does it confer any such jurisdiction on the CBI, in the event the CBI is not vested with such powers otherwise in law. Full stop. Next para. The petitioners have made out a strong prima facie case, firstly, on the jurisdiction of the CBI to carry on investigation within the state of West Bengal and stroke or even assume jurisdiction to initiate such investigation in respect of an offense allegedly committed in the state of West Bengal. Full stop. it is an admitted position that the consent granted under Section 6 of the 1946 Act had been withdrawn by the state of West Bengal long prior to the lodging of the complaint, comma, on November 16, 2018 by a notification, by a gazette notification. Push up next para. The question which arises for the purpose of ascertaining jurisdiction is the situs of the alleged offense. Full stop. Next para. I find from the complaint lodged by the deputy general manager, comma, State Bank of India, which is annexed to the writ petitions, comma, that as per the allegation of the said complainant, comma, the offense took place on account of various associates, comma, prior to the merger of the concerned company being maintained at the industrial financial branch of the said bank at Kolkata and the commercial branch at Kolkata. Full stop. It is categorically alleged under the second bullet point in serial number 4 of the complaint that the fraud alleged had taken place at both the aforesaid branches, comma, from where the accused had diverted the funds, comma, manipulated books of accounts with an objective to defraud the bank and to gain unlawfully at the cost of bank apostrophes funds. Full stop. Next para. The rest of the complaint revolved around the first two paragraphs, comma, which center around an alleged offense committed in respect of two branches of the State Bank of India, comma, both of which are located in Kolkata within the state of West Bengal. Full stop. Next para. In the first information report lodged in pursuance of the said complaint, comma, however, comma, in paragraph number 5, comma, the place of occurrence was, comma, all on a sudden, comma, mentioned as the Jharsuguda unit of Messrs. Of the company concerned, and two other places at West Bengal and one place at Andhra Pradesh. Full stop. However, comma, if we enter into the origin of the FIR, comma, we find in a separate sheet attached to the FIR, comma, annexed at page 74 of the present writ petition, that the genesis of the FIR was solely the complaint lodged by the Deputy General Manager, State Bank of India, SAMB Kolkata, having address at Shakespeare Soroni in Kolkata. Full stop. Next para. Thus, comma, even ex facie, comma, the place of occurrence mentioned in the FIR itself does not tally with the complaint on the basis of which the same was lodged. Full stop. I still could have understood if in the appropriate column, comma, the FIR, the genesis of the FIR was mentioned to be several complaints lodged in different states. Full stop. However, comma, it is found from the separate sheet attached to the FIR that it is based totally and exclusively on the complaint lodged by the Deputy General Manager of the SBI branch as indicated above. Full stop. Since from the complaint itself, comma, as already discussed, comma, we find that the entire allegations of offense relate to the city of Kolkata within the state of West Bengal, comma, we have to look at the provisions of sections 5 and 6 through the focal lens of the state of West Bengal. Full stop. As indicated above, comma, since the consent of exercise of powers by the CBI has under section 6 has been withdrawn by the state of West Bengal long back, comma, we find that the CBI prima facie did not have any jurisdiction to initiate any investigation or exercise its powers and functions under the 1946 Act, since it derives its very authority to initiate such action from Section 5 of the 1946 Act, which is circumscribed by Section 6 of the said Act. Full stop. Next para. Even on the second aspect of the matter, proceeding on the premise and assuming that the CBI did have jurisdiction to initiate the investigation, the officer of the CBI, within the contemplation of Section 5 within bracket 2 of the 1946 Act, has to operate and exercise powers as an officer in charge of a police station in the area of offense, and when so exercising such powers, shall be deemed to be an officer in charge of a police station discharging the functions of such an officer within the limits of his station. Full stop. Read in conjunction with sections 154 to 157 of the Code of Criminal Procedure, at least prima facie, this court cannot but come to the conclusion that the report being lodged with the special CBI court in Bhubaneswar at Odisha in pursuance of a complaint lodged and an FIR registered in Kolkata within the state of West Bengal is in direct contravention of the entire scheme and ecosystem provided by sections 154 to 157 of the Code of Criminal Procedure. Full stop. Next para. Thus, seen from such perspective as well, I find a strong prima facie and arguable case having been made out by the petitioners. Push up. Next para. Coming to the issue of territorial jurisdiction, it is not the exercise of powers by the special court CBI in Odisha, which forms the cause of action of the present writ petitions. Full stop. Rather, the challenge has been thrown against the genesis of such investigation, which is the complaint, giving rise to an FIR. Full stop. Since the complaint was lodged and the FIR was registered within the territorial jurisdiction of this court, in view of the nature of the challenge in the writ petitions, this court is of the opinion that this court has territorial jurisdiction to take up the matter. Full stop. Next para. That apart, the de facto complainant has raised an issue as to whether the non-implement of the State Bank of India in its own capacity and the other consortium banks vitiates the filing of the writ petition. Full stop. With utmost respect to the erudition of learned senior counsel for the de facto complainant, I disagree with such proposition, since the complaint itself does not disclose the complainant being the representative of his bank and stroke or any consortium of banks as such, nor does the complaint refer to any antecedent regarding him being authorized to lodge the complaint solely and exclusively in the capacity of an agent of his bank. Full stop. Next para. Moreover, I have my doubts as to how far a complainant can be heard on the legality and veracity of a first information report, since the role of a de facto complainant, for the present purpose, ends with the lodging of the complaint. Full stop. The domino effect which takes thereafter on the basis of such complaint is rather not the lookout of the complainant. Full stop. As such, the point of non-implement cannot be entertained. Full stop. Next para. Insofar as the reliance of the CBI on its circular dated October 3, 2020 is concerned, as held earlier, the same cannot be a justification for prima facie flouting the law governing the subject. Full stop. Coming to the judgment of the coordinate bench which has been cited before this court, comma, I find that the conspectus of the said challenge was different from the present. Full stop. Whereas in the present case, comma, the very genesis and initiation of proceedings and investigation by the CBI has been assailed, comma, in the said case, comma, the prayer was merely the transfer of a case from Calcutta uh, between Calcutta and Ahmedabad. Full stop. In such limited context, comma, the learned single judge had taken into consideration the circular of the CBI dated October 3, 2020. Full stop. However, comma, it is evident from the cited judgment itself that the points raised in the present case, comma, being the jurisdictional error in the light of sections 5 and 6 of the 1946 Act, read with sections 154 to 157 of the Code of Criminal Procedure, were neither raised nor adjudicated before the said court. Full stop. Hence, comma, with utmost respect, comma, the cited judgment cannot be a precedent for the questions which have now arisen before this court, and as such is not binding insofar as the present case is concerned. Full stop. In such view of the matter, comma, as already held above, comma, the petitioners have made a strong prima facie case for hearing of the writ petition of merits. Full stop. Unless the proceedings initiated on the basis of the FIR which has been assailed herein are stayed, comma, there is every possibility that the writ petitions will become infructuous before they are finally heard on merits. Full stop. A word of caution here, comma, caution here, semicolon. This court is not per se looking into the jurisdiction of the CBI court in Odisha in isolation, but is examining a challenge against the very initiation of the proceeding, comma, of which the report filed before the Odisha special court, CBI court, and the other actions taken by the CBI are merely an offshoot and a consequence. Full stop. Next para. This court is also not unmindful of the fact that till date, comma, no charge sheet has been filed and the case is still at the stage of investigation by the CBI, comma, the very basis of which has been challenged before this court. Full stop. Hence, comma, the grant of an interim order in connection with the present writ petition shall not tantamount to usurping the jurisdiction of the CBI court otherwise. Full stop. Otherwise than in the context of the FIR, which was the origin of the same. Full stop. Next para, be that as it may, comma, in view of the above observations, comma, there shall be stay of all further action taken on the basis of and in continuation of the investigation initiated in connection with FIR number RCBSK 2022 capital E 0001 dated September 6, 2022 under the sections mentioned therein till June 30, 2025 or until further order, comma, whichever is earlier. The respondent shall file their respective affidavits in opposition within 3 weeks from date. Full stop. Reply, if any, shall be filed by June 13, 2025. Full stop. The matter shall next be listed on June 17, 2025. June 17 হবে না. Matters shall next be listed on June 20, 2025 for hearing.
Only one indulgence. May I
Yes,
say?
Mr. Mitra.
In place of 3 weeks, it can be 4 weeks because there is a process of
4
vetting.
weeks will take us to the vacation.
There is a process of vetting, my lord.
আচ্ছা, very well. Then we'll extend the entire timeline, the structure. আচ্ছা, তাহলে ইন্টারিম অর্ডারটা যেটা দিলাম সেটা জুন 30 না করে till July 15, 2025. Affidavit in opposition by June 13, 2025. Reply, if any, by June, within a week. Can you do that? Reply within June 27. 2 weeks.
Most of
June
most of
27. our returnable date will be July 4, 2025. তাহলে make it interim order till July 31.
July 31.
It will be too
Most
close
obliged.
otherwise.
I'm most obliged.
Thank you so much. Acha, original set matters will be taken up now.
Yes.
Because you have a different point there.
Hello, today.
Now, right now.
Very
Those are
short.
fixed together to be taken up for here. Yes.
But there's an
Milord,
These points are there. The points taken by Mr. Agarwal. It's on a different footing.
Their intervention is there.
their intervention is there, which now becomes
Intervening application is there in respect of one matter.
If it's not on the same points, then is Mr. Agarwal there also in that matter?
that matter, Milord, Paradip Bhante. There, Milord, fraud against the main promoter, Milord, has been.
That's on an entirely different ground.
Yes, entirely different ground.
Then we can take it up on some other day. We'll take it up on.
These writ petitions, the appellate side writ petition has been assigned to you. Before the Honorable Justice Tirthankar.
Take it up with the Chief Justice
But I pointed out to your lordship on the beginning.
on the very first day.
That was suppressed, Milord.
No, nothing is
We'll consider the suppression when we take up.
You lost it,
Original set
fix a
matters
date.
গুলো বলে original set matters গুলো একটা order since there is a distinction between the points raised in the present applications than those tagged with these on the appellate side, let these matters be listed next on next Friday is a holiday, so on May 16, 2025.
May 16.
May 16th, 2025. এটা আর থাকবে না পরের দিন আর থাকবে না। For such purpose, let these matters be detached from ওই appellate side যে তিনটে ম্যাটার আছে ওইগুলো নাম্বার দিয়ে করে দেবে। Detagged from. Those are the topics.
I'm most obliged.
Thank you so much. Please. তুমি শুধু WPA গুলো যেগুলো হ্যাঁ তুমি অন্যগুলো লিখো। চল পড়। কল তো করো।
অনেক যেতে হবে বলছো?
সবকিছু এই কাগজ।
একটা ম্যানুয়াল আছে কিন্তু
এই জাজমেন্ট গুলো এটা
ম্যানুয়াল আছে। সিআরপিসি
যা যা আজকে দিয়েছে এটা সব এখানে থাকবে আর কাগজগুলো চল আর দেখা যাবে না ওদের একটু নিচে হ্যাঁ ঠিক আছে কল করুন যেটা থাকবে তাদের জন্য ওদের বই ছিল Not today.
Dada, item number 5 is Rajan.
Not today or not?
After vacation, because of talk of settlement, his clerk just informed me that.
Talk of settlement is not convincing. I'm making it not today. If it can be settled, it can be settled in a week. Otherwise, not. On the prayer of the petitioner, the matter is adjourned for the day, but your name will be recorded. Yes. নেই যখন ছেড়ে not today কোন order
My lord, not today. I'm praying for Mr. Pankaj Haldar is appearing for the petition. I'm praying for.
I'm making it not today.
My lord.
I'm not recording any order.
My 7, my lord, last occasion also petitioner was not there. I was directed to file the compliance report because on that day I submitted.
You have given a copy to them? Complaint?
Yes, yes.
Achha, a compliance report filed by the alleged contemner today be kept on record. Full stop. Let the matter stand over till May 16, 2025.
Order has been complied with.
Even then, if you insist, I'll record your insistence and say that because you have a resolution, that's why, not any other reason. Otherwise, I will dismiss the control.
Because even there is a direction to serve copy of this contempt application upon me, they have not served.
They have not been appearing consistently.
They are not appearing because connection has been given long back. They have received.
So I'll just record a one-line order, Mr. Mukherjee, that Mr. Mukherjee learned counsel for the alleged contemner submits that despite there being an illegal resolution of the bar, he insists that the petition. I'll just record that line so that tomorrow there is no boycott of my court. You do that once you do. What should you do? Tell me, I can dispose of the matter right now. But I'll record one sentence. This is not a threat to you. I agree with your proposition. It's illegal. What should I do? Tell me.
May take back the complaint.
No, that will take. That is now court's property. Yes. যা order record করলাম তাই হবে next.
My lord, I am appearing for the petitioner in the next matter.
Which matter? Next matter.
Next matter. My lord.
Yes, yes. Move the matter. Then.
Yes, my lord. This is a.
Eight. What is the matter? Yes. You
My
have
lord,
that.
they are,
Yes. Move.
my lord, the petitioner, my lord, filed this, my lord, contempt application that for a order, my lord, passed on, my lord, 7th December 2023.
Oh,
my lord.
they
It's my lord's order.
unconditional apology.
SBI cards.
Have you complied?
My lord, the thing is that I am tendering my unconditional apologies.
That you already tendered on the last occasion.
My lord, the thing is that the person who has trying to settle out these matters, suddenly his father was passed away. And
When did he pass away?
My lord, I just got information today itself.
We passed the order on 11th April.
My lord, I know, I'm tendering my unconditional apologies.
No, unconditional or non-conditional or conditional?
Seeking for just 4 weeks time, my lord.
No question of 4 weeks. What is just 4 weeks? We recorded an order 1 month back. Today we are on 2nd of
My lord, considering the situation.
Almost a month. 4 weeks back.
My lord,
no.
My lord, there has been already a communication between the participants.
Whatever. That was already there on the last occasion.
No, my lord,
I had recorded that there's an email which indicates that you are agreeable to comply with the order with unconditional apology, citing oversight on your part.
My lord,
You sought 3 weeks' time. We are taking up the matter after 4 weeks and on the returnable date. When did this person's father die? You have to give the date if you take that plea.
My lord, I need to take the instruction from this. I cannot connect with that person, my lord.
No, if you have not complied with, then I'll issue a rule of contempt.
My lord, we are
Father or no father, I'll issue. No, these frivolous grounds cannot be taken. Father, the death of a father is definitely not a frivolous ground. Don't misunderstand me. But if you can't say when he died, if he died yesterday and I passed the direction on 11th April, that's no excuse.
I don't think so, my lord. That has happened on yesterday. But my lord, I am not getting the proper instruction from a client also. But we are doing.
If you say that, I'll record that and issue a rule.
No, my lord, kindly forgive us 2 weeks time, my lord. We will settle this matter. We will definitely settle this matter.
No question of settlement. To comply with the order.
My lord, we will comply this matter. We will comply with this, with the direction given by this honorable court.
So do
My
it.
lord, the civil.
Yes.
My lord, the civil score has further been downgraded, my lord. Now it is 546.
I will issue a rule of contempt. We are giving you 1 week's time.
My lord,
you have to engage some other accountant there.
My lord, surely, my lord, the honest time should be given. My
Learned counsel for the alleged contemner submits that due to the demise of the father of the accountant who is in charge of compliance with the order, the order could not be complied with and tenders further unconditional apology on such count, seeking time to comply with the order of this court. Full stop. Next para. I find from the order dated April 11, 2025 that a similar strategy was adopted by the alleged contemners when they had also tendered their unconditional apology and expressed agreement to comply with the order. Full stop. Next para. Since till date, the order has not been complied with, this court is apprehensive of the motive of the alleged contemners. Full stop. On the query of court, the date of demise of the father of the accountant in charge cannot also be disclosed, which casts further suspicion on the intentions of the alleged contemners. Full stop. Be that as it may, in view of the further unconditional apology expressed by the alleged contemners, I grant 1 week's time further to the alleged contemners to comply with the order of this court. Full stop. Next para. It is made clear that for such purpose, in the event the concerned accountant is not available, the alleged contemners shall ensure that some other person is deputed to comply with the order of this court. Full stop. The matter shall next be listed on May 16, 2025. Full stop. It is expected that on the said date, an affidavit of compliance shall be filed by the alleged contemners. Full stop. However, in the event such compliance does not take place, appropriate directions shall be passed by this court in that regard.
Obliged.
Thank you. Next.
My lords, I appear for the petitioner. My lords, this is an incentive scheme matter whereby directions.
Is this appearing for the first time or directed?
No, my lords, service has been done. My lords, the appeal is pending in division bench. My lords, my humble prayer that
It is appearing in the list.
it is appearing in the list. The next date is 9th of June. But
Then after that,
my lords, if I may pray, the matter can be taken out of the list with liberty to mention.
we'll do that. You are for the petitioner.
I am for the petition.
Learned counsel for the petitioner, comma, in his usual fairness, comma, submits that since an appeal is pending before the concerned division bench against the parent order in respect of which contempt has been alleged, comma, let the matter go out of the list for the present with liberty to the parties to mention for inclusion as and when the appeal is disposed of and stroke or appropriate orders are passed in the appeal. Full stop. There is substance in such contention, full stop. Accordingly, let the matter go out of the list with liberty to the parties to mention for inclusion in the list as and when appropriate orders are passed in connection with the pending appeal. Thanks. এখন out of the list.
Item number 10.
My lord, I am for the appellant. My lord, affidavit of service.
My lord, there was a direction to file affidavit in opposition. My lord, I am appearing for the alleged contempt of bank. My lord, here is my affidavit.
Mr. Singh, you have filed.
My lord, on the my lord,
You have closed it.
my lord, I kindly give liberty to correct the cause title, my lord.
Yes, my lord, the name would be Abhishek Patel, my lord. I have indicated.
I gave you that liberty on the last occasion.
These are taken, my lord. These are not on those sets. These three matters are.
But as far as the insurance company is concerned, my lord, the name is also to be changed.
Leave is on the prayer of learned counsel for the petitioner, comma, leave is granted to the petitioner to change the current incumbent in the post of the alleged contemner, as well as the alleged contemners. Both the persons have changed. Your person has also changed. She has also changed.
My lord.
So, the necessary consequential amendments to the cause title of the contempt application shall be carried out by the learned advocate for the petitioner during the course of the day. Full stop. The affidavit in opposition filed by the filed on behalf of the alleged contemner number 1 today be kept on record.
Yes.
My lord, as far as my lord, my client is concerned, my lord, last week, my lord had taken up, my lord, there were 9 contempt applications last week. My lord, 3, my lord, item 10, 11, and 12 are today. My lord, your lordship had fixed up those, my lord, on 16th of, my lord.
I'll fix this also on 16th.
Lordship, my lord, in the meantime, my lord, affidavit, kindly, my lord, grant me. My lord, I'm giving the name to my lord.
Very well. The added, the alleged container number 2 shall we had directed you to file on the last
Lordship.
The time for filing affidavit in opposition by the alleged container number 2 is extended for a week from date. Push up. Replies, if any, to the affidavits in opposition shall be filed on the returnable date. The matter shall next be listed on May 16, 2025. Same order in respect of the rest too also?
Yes, your lordship. 10, 11, and 12.
Lordship. My lord, one humble prayer. My lord, I do not have the copy of the writ applications. My lord, I had made the copy.
My lord, I served all affidavits are served.
My lord, not the contempt. My lord, the original writ, my lord, I didn't, because I did not appear in any of the writs, any of the 12 writs, my lord, I did not appear.
You can take an inspection.
Yeah, my lord, I had made the for obtaining the certified copy, but my lord, the file is before my lord's court, it could not go, my lord.
Please give him a copy of this writ petition. Mr. Singh will pay for the photocopy.
My lord, my lord, at the time of
order in the next two.
Yes,
sir. At the time of rising, Lord, I shall mention because my lord, in one of the matter, my lord had asked my client to put cost, my lord.
Yes.
My lord, this was the matter. My lord, Mr. Qazi Sajjad Alam was the advocate. My lord, I contacted him. My lord, he says that his name is wrongly appearing. He is not the advocate. My lord, then my lord, the cost has to be paid. My lord's order has to be complied with. My lord, the lordship, my lord, since I am unable to pay cost, my lord, and my lord, your lordship will again take me to task. And this gentleman is saying that he is not for the petitioner.
But that matter is not before me. On 16th only I can pass order.
My lord, if I may indicate, item number 13 and 14, my lord, were listed together. My lord, that is the problem. I believe, my lord, my learned friend is appearing for item number 14, my lord. Those were separate matters, but were tagged up together. In that matter, Ms. Shoni Ojha was appearing for another bank, your lordship.
That cost matter?
No, my lord, this is the cost. The item number 14 is the cost matter where I was appearing for the bank and my learned friend, my lord, was appearing for the petitioner. I believe his name will be there, my lord.
Lord, I do not know, Lord, to whom to contact.
We have called up to 12.
Lord, up to 12, yes.
This applies up to 13.
No, Your Lordship. To date, it's 12. My lord, in that
No, no,
order.
today's matters.
Yes,
The
today.
same order will be passed in up to 12.
Up to 12,
Yes.
10, 11, and
We are
12.
12. So
Yes,
13 will take up now, 13 and
My
14.
lord, with this cost, my lord, I'm still, my lord.
So 13, 14 we have not yet called.
My lord, it is not in 14, my lord. It was with the last week's
Yes,
order.
yes,
my
last
lord.
week's order.
That I cannot do anything with that. What can I do with that? That matter is not before me.
Since, my lord, the parties were here, my lord, so I thought that
Maybe,
it can be
but
clarified.
that matter is not before the court. I cannot do anything on it.
My lord, that is what I was trying to indicate. My lord, on that particular day, two matters were tagged up together. My lord, this order has been passed in the matter of Shubham Mahapatra, I
Whenever
believe.
it comes,
Lordship.
next matter
Grateful,
call on
Your
the next
Lordship.
13.
Grateful.
Yeah, 12. Item number 12. 12.
ওটা কি দিচ্ছে?
Affidavits.
তাহলে তো
Affidavit of
কি?
service.
তাহলে affidavit of service file today be kept on record.
11
এটা
and
13,
12.
13
11
কেউ
and
নেই দেখুন not আজকে বাড়ি resolution
11.
not to.
10, 11.
You move, please move away from the microphone and talk to my officer.
Yes, my lord. I served.
Away from the microphone, not closer to the microphone.
I served all.
Thank you very much for that.
the-
13 not
the-
today,
the-
next. Yes.
My lords, I appeal for the petition. On last
Similar.
uh,
Appeal pending.
no, my lords, appeal is pending, but no steps have been taken.
Not sometimes, my lord, 2 weeks times, my lord.
2 weeks time.
My lord.
Very well, 2 weeks time.
My lords, appeal was filed on 22nd May 24.
20?
22nd May
20 which year? 2024, 1 year back.
My lords.
22nd April.
22nd May.
May. 1 year back.
Last
No,
chance.
we'll issue a rule.
No, my lord, last chance, my lord, 2 weeks, my lord, kindly, my lord, last chance.
Drama sort of thing, but last chance and all.
Really, my lord.
1 year, for 1 year it is pending. If you could not find time to have it moved.
No, my lord.
What? No, no, no. 1 year.
My lord.
What steps did you take in the meantime?
That is true, my lord.
Learned counsel for the petitioner submits that although an appeal has been preferred against the original order in respect of which the contempt has been alleged, comma, the said appeal was filed on May 22, 2024, that is about 1 year back, but no steps have been taken in that regard. For sub next para, learned counsel for the alleged contenders seeks 2 weeks time to take appropriate steps with regard to the appeal. Full stop. It is evident that despite the long pendency of the appeal for about a year, comma, the alleged contemners have been taking a chance since the contempt application was not before this court. Full sub next para, be that as it may, comma, in all fairness, comma, as a last chance to the alleged contemners to obtain an order from the appellate court, comma, the matter is adjourned till May 16, 2025, full stop. However, comma, it is made clear that in the event no order can be obtained by the alleged contemners in the meantime from the appellate court, comma, appropriate orders shall be passed in connection with the contempt application on the written matter. What is this?
My lords, affidavit of
Service. প্রথম লাইনে affidavit of service filed to be kept.
obliged.
Mr. Adok,
My lord.
no smile next time.
My lord. Definitely, my lord. Great.
Not today.
I was to reply to their. My lord, last occasion was
Yes,
directed me to ask both of us to file written notes of argument. I am filing my written notes of argument with respect to both the matters.
Yes, compositely.
Compositely, my lord, because there are so many voluminous pages of writ application, my lord.
No, you are filing to separate,
Separate.
not composite.
But I understand, Lord, but submissions were made with respect to only one. 8125. Because they were
তোমার
basically.
একসঙ্গে appear করছিল
হ্যাঁ,
No, both
Lord,
were appearing.
both are appearing, but submissions were with respect to
8125,
8125.
my lord, I prefer
The reason
challenge the writ application on the basis of the illegal acceptance by the competent authority.
if the
That is the
And what is the other one?
other one is, my lord, the matter thereafter, my lord, they called us for a hearing. They give a speaking order. We have challenged that before this honorable court. Honorable court has set aside it because there was no reasons. Then again relegated us back to the competent authority. Competent authority again issued the same order justifying its action, which was challenging one could say that it application. Because 8125 is the mother challenge.
Perhaps not.
Perhaps what?
Not because the last order that was passed, that was in 9th of yes, that's 2023.
So basically, the origin is the first challenge.
That takes
And
care of
he
it.
says that same order has been repeated by the
The first repetition goes, everything goes.
Yes, that is also my contention. So far as the 8125 is concerned.
No, if the first repetition remains, if it,
if the first repetition is dismissed, the entire thing goes.
yes. No,
Because
why?
he will not
if
have.
Even if the genesis is not bad,
But what is the issue? If you
but then also yes, because it is
8125 minor, if it ultimately succeeds.
8125 is the mother, the
Yes,
parent
if
one.
it ultimately succeeds,
Right,
then
Mr.
everything goes.
Now, his first submission was with respect to limitation for filing Form A. Lord, may I place that provision?
Will you be filing your written notes today, or
Lord,
you will also be filing?
Yeah, I'll file.
Then you can hand up that so that we can.
Please, Lord, if during the course of argument, I think some modification will be required.
Very good.
That's the reason, Lord.
No, if you file that, then I'll be marking there only. Then I won't be taking separate note. That's why.
Acha.
Anyway, I'll be taking separate
In
notes.
that case, I can give supplementary also, if required. If required.
No, need not. File it together. So take argue your points. Yes, one
Lord,
limitation.
Kindly, Lord, comes to the rules once.
Rules গুলো দিন, বইগুলো দিতে হবে বাবু। ওই ওয়েস্ট বেঙ্গল
Apartment ownership act এর বই
promoter
আছে?
side.
Lord, may I?
Apartment ownership.
Lord, may I not?
No, I have. For a change, the court also has the books. You have to find those out. It's a literally Himalayan task for them. এগুলো কোনো একটা
Code number 1, it's very good. A, B, C, D, not so.
Yes, that's the best policy. We don't have that space. ABCD is down, not here.
Yes.
We don't have that space below. Code number 1 is the chief's code, Mr. Kornkar.
Same size 8 also.
8, yes, other 12 also.
12, perhaps these two are bigger than 12.
Awesome.
Perhaps, Lord, I do not.
Now 12 is very large. 12 is very large, equivalent to 8.
Because
Same
yes,
scheme,
yes.
same scheme, 4 sides. 11, 12 are also good, large.
Yes.
We did matters there, it is large.
Lord, kindly comes to Rule 2A.
Yes.
The sole owner or all the owners or majority of the owners of every property shall submit his or their property within 3 years from the date of completion certificate issued by competent authority. So, Lord, the term used here is, Lord, completion certificate. Lord, what has been shown to your Lordship, if your Lordship sees the reply first, their reply to 8125. Page, Lord, I'm sorry.
Reply.
In 8125 reply টা একটু বের করে দিন।
No, ঠিক আছে। 8125. Yes.
8125, page 119 onwards.
One 119 onwards, yes.
Lord, your Lordship would find it's there, Lord, document. This is partial occupancy certificate, Form H, turns over, and your Lordship will kindly turn over till Lord 124 onwards. Your Lordship would find 124A. Your Lordship would find all are Lord occupancy certificates. Kindly comes to 120.
All are partial.
All are partial occupancy certificate.
No, some are occupancy certificate.
Yes, occupancy certificate also.
Very
Except one, my lord, all are occupational certificates.
Huh. Kindly comes to page 125. This is the basis of his argument for limitation. 125, my lord. The last column, kindly sees how he says within 3 years from the date of completion certificate. Although, my lord, he annexes, my lord, occupancy certificate, but this is for completion certificate. This is the first flaw.
No means no completion certificate as
Completion certificate. And the delay, your lordship would find 7 years, or are from computed from the date, my lord, when the occupancy certificate was issued.
So you draw a distinction between this completion certificate and occupancy certificate.
Yes. And why, my lord? The
Occupancy relates to
statutes,
occupancy only, and
the
completion is
statutes, there is
yes.
a difference. The difference is, my lord, completion certificate is issued upon the entire project based upon the, my lord, sanction plan. Once the entire project is completed as per the sanction plan, only then completion certificate is issued. But, my lord, there may be a case, my lord, where partial, my lord, constructions come up in phases. Thereby, my lord, in a case where 10 blocks are to be constructed, in such a situation, my lord, nobody will sit back, my lord, waiting for the 10th block to come up when the first block is completed 5 years back. Similar, that's why the statutes provide for two types of certificate. One is if the building is habitable, then occupation certificate or partial occupancy certificate is issued so that people can enter and start living in that particular block or building.
So completion certificate cannot be issued for a particular block or a particular building. The total thing. Under which provisions of law? Just
Now, Lord,
show me the
kindly
provisions.
comes
Of
to
occupancy certificate provision and completion certificate.
Lord, kindly comes to the RERA Act first. Lord, that's the Real Estate Regulation and Development Act 2016.
What are these in West Bengal with the colorful?
Lord, I'll require only four things. Lord, one is the RERA Act.
RERA Act.
The other one is Lord West Bengal Lord RERA Rules 2021.
RERA, it a rule C. Now with Act.
Rules
yes, both are here.
Yes. So, my lord, that is there. I will also show to your lordship West Bengal Municipal Act 1993.
এগুলো শুনে রাখুন আপনাদের জন্য বলছেন উনি এগুলো বার করতে হবে
West Bengal Municipal Rules Municipal Act 1993.
1993 and
Building Rules 2007.
Thank you.
Building Rules 2007. West Bengal Municipal Building Rules.
If you can from now on, Mr. Karmakar, and just make it, tell it to your friends also if you can. At the time of starting arguments, if you want to rely on several statutes or one or two statutes, you can just give a note, prepare a note and just give it at the beginning so that we can bring or arrange.
Initially, we used to do that.
Yes, that was the prevalent practice.
Whenever you used to refer to books, we used to come and hand up a slip so that.
Yes, we could bring the books from the citations also.
Yes.
For citations, now we have the online thing and yes. So let us proceed with RERA first.
Lord, kindly comes to 2Q. Section 2Q first.
In English or Hindi?
In English.
Yes. Yes.
Completion certificate. Means the completion certificate or such other certificate by whatever name called issued by the competent authority certifying that the real estate project has been developed according to the sanction plan, layout plan and specifications as approved by the competent authority under the local laws.
And ZF speaks about this other thing.
Occupancy certificate means the occupancy certificate or such other certificate by whatever name called issued by the competent authority permitting occupation of a building as provided under local laws which has provision of civic infrastructure such as water.
Why should we read the provisions of the RERA Act into this?
Lord, because this definition, this distinction you'll find here first. Definition. There is nowhere else. But the use of these two things, Lord, were there since Lord the building rules and all municipal act.
But these were never defined anywhere.
Lord, that's why I demonstrated this.
So this is the Parimateria statute we want to.
Yes, latest one, Lord, that shows the distinction. And when I place the other acts also, your lordship would find
something similar.
Lord, they are different. So, Lord, your lordship, this is the definition part.
Yes.
Now, Lord, kindly comes to the Municipal Act. Bengal Municipal Act, West Bengal Municipal Act 1993. First, Lord, Section 115A. 115A, capital A.
115A, okay. Yes.
But you kindly got it now?
Got it.
Lord, 15A, 4, sub-rule 4.
Hmm.
In the case of any new building for which an occupancy certificate has been granted or which has been taken possession of immediately after the commencement of the such act, such payment shall be made, such return within 30 days of the expiry of the quarter in which such occupancy certificate is granted or such possession is taken. Lord, this act at section 212, Lord, also deals with completion certificate. Kindly, Lord, comes to 212.
You have done your homework very well. You have done your homework very well. I smiled at him, but you have done your homework. Yes. Completion certificate. Yes.
Every person submitting an application with building plan or a work to which such application relates shall within 1 month after the completion of erection of such building or execution of such work deliver or send or cause to be delivered or sent to the municipality a notice in writing of such completion accompanied by a certificate in such form as may be prescribed and shall give the municipality all necessary facilities for inspection of such building work. No person shall occupy or permitted to be occupied any such building or such and such any part affected by any such work until permission has been granted by the municipality in this behalf in accordance with the rules of regulation such and such.
Therefore,
Like,
occupation
that's the-
certificate has to necessarily follow completion certificate.
Prior to the completion certificate, that's the reason. Kindly see 212 and
No, if
150
212 is to be read, which is applicable here also,
200
then occupation certificate means that there's already a completion certificate. Otherwise, it cannot be issued.
But occupancy certificate, that's the reason there was no concept of occupancy certificate prior to Milord 2002.
No, 1993, there's you have placed the provisions. 115A4 speaks about occupation.
115A has been introduced in 2002. It was not there.
Very well.
It is only for the purpose so that Milord, because of the delay of completion certificate, people do not wait to get into their
But
house.
all this is after 2002, so all these apply.
Yes.
So when
Milord,
this happened, all this happened.
what I'm
No,
trying to
it was there.
What I'm trying to
No,
demonstrate.
if you
to your
read
lordship is-
115A along with 212,
My lord.
then occupation certificate can only be issued after completion certificate.
No, that's the. I'm bulch.
He has done his classwork well. Yes.
Lord, what I'm trying to impress upon your lordship is, Lord, that completion certificate is granted on the entire project. If the completion certificate is there, there's no requirement for occupancy certificate. And he considers this. Why the occupancy certificate will be required? Because the project is not complete, but the building is habitable. That's why I showed your lordship the definition.
So you're dissociating this occupancy certificate with actual occupation.
My
Completion,
actual completion.
Yes.
But else there was
But
no
if it says
requirement.
212.2 says no person shall occupy or permit to be occupied any such building or use or permit to be used any building or any part thereof affected by any such work until permission has been
This
granted
permission is occupation certificate.
in this. Yes.
This permission is occupancy certificate. But else,
Unless permission granted by the municipality and in accordance with the rules and regulations made under
rules shall show. Rules shall show. This permission is occupancy certificate. Not else. No, there is no requirement for this occupancy.
No, but we see the proviso provided that if the municipality fails within a period of 30 days of receipt of the notice of completion to communicate its refusal to grant such permission. This permission pertains to occupancy.
My lord.
So everything happens after the completion.
No, cannot be.
See the language? To communicate its refusal to grant such permission. Even after 30 days from completion, if it fails to communicate its refusal, that person then may make a representation for occupation. But before that, before the completion, he cannot even make this application.
Now, Lord,
doesn't have a right.
If this is what this act said, Lord, what was the requirement for introducing 115A? Lord, 115A was introduced only, Lord, to bypass this problem. Lord, kindly consider the reason for amendment. If
then 212 could have been amended.
what
That's
was-
a
what
very
was-
far-flung way to
the reason is for assessment. Lord,
to bypass 212. Why should I introduce a new
115A,
elaborate provision? I would have just amended that.
Lord, 115A is for self-assessment. Now, my lord, what happens?
It operates in a different context.
Yes, the entire project is on the basis of completion certificate. Only then the project can be handed over. But with respect to when there is a building, as I indicated, suppose there are 10 blocks in one project. Lord, nobody waits for the 10th block to be constructed, and this first block which was constructed 5 years back, it will stay vacant.
But before the
here also
10th
same case.
before the 10th block is constructed, as per section 212, you cannot take a possession.
Lord, the possession is handed over by the occupancy certificate. That's the permission. SSC number is generated.
But this is couched in a negative language. 212(2) still remains in the statute. Same statute.
Lord, until that
It has to be read with that.
Until that permission, as you may I read it for your lordship for proviso. Provided that if the municipality fails within the period of 30 days of a receipt of the notice of completion,
Yes.
notice of completion and completion certificate are two different things.
Achha.
Lord, I shall show to your lordship from the rules also, they're different form. Notice of completion to communicate its refusal to grant such permission, such person may make representation writing such and such chairman after such inquiry as he may think fit, and after giving such person an opportunity of being heard, grant such permission or communicate his refusal. Lord, this is completely with respect to Lord. Yes, Lord, kindly sees the proviso has also been amended in 2002. So, Lord, this occupancy certificate thing was introduced for the first time in 2002 only. That's why this amendment was made. From such, your lordship finds there's an amendment. So, this was introduced by way of 2002.
But that doesn't introduce, but doesn't make a difference in that.
Lord, such person, when I apply.
2 remains.
Lord, when I
what you say is correct, then 2 would be deleted just.
2 remains, but until the permission is granted. That permission is below this occupancy certificate. Completion is with respect to completion of the building in toto with the sanction plan. The sanction plan is not with respect
but notice
to one
of completion, then you're distinguishing between completion as used in notice of completion and completion certificate. Completion cannot have 2 meanings within the same act.
In a multiple blocks project, there are 2 things.
It's not clarified. Completion, the same word will have 2 meanings.
This will be further clarified when I place the rules also and read with other Lord. Everywhere your lordship would find consciously the legislature has used these 2 words differently on different context. Even in same provision, in one provision your lordship will find there is a usage of occupancy certificate as well as completion certificate. So that is where the distinction is created. So your lordship recalls, my lord, your lordship had passed an order while dealing with the adoption laws, Lord, with respect to parents and my lord, single mother. Lord,
Yes.
I made that argument with your lordship, my lord. There also, your parents, when the word parents were being used, your lordship your lordship view
So
was.
there the
Lord, why
languages
single
of the sections were different.
Lord, here also I'll show.
You just see, if you come to 212, there is a notional coherence. I mean, these are not discrete, separate things. One says every person submitting an application with building plan shall, within 1 month after the completion of erection of such building or execution of the work, do such and such things. 2 says, no person shall occupy or permit to be occupied any such building or used such and such by any such work until permission has been granted by the municipality in this behalf. Proviso says if the municipality fails within a period of 30 days of receipt of the notice of completion, this completion at least relates with completion as used in 1.
Lord, until permission, your lordship, Lord, has to read that also, Lord.
Yes.
Permission issued in this behalf accordance with the rules and regulations made under this act.
Rules cannot override the section.
No, Lord, definitely not.
Those permission can be given in terms of the rules. That we can understand. But permission in the first place has to be given by the municipality. But it starts with no person shall occupy or permit to be occupied any such building or use with such and such until permission has been granted. Very well. That is irrespective of completion.
Well,
but proviso makes it clear.
Yes.
if the municipality, you have a right to enforce that right. I mean, to get that occupation certificate, provided if the municipality fails
Notice
within
of
a period of
completion.
notice of completion. This completion has to relate to subsection 1.
This notice of completion is
Completion of erection of such building.
No, this notice of completion is a separate form itself. And that follows the occupancy certificate. I shall show from the rules.
Where is show us?
From the kindly comes to before going to the West Bengal municipal rules, may I please the RERA rules first?
What?
Kindly comes to the RERA rules. 16.
RERA is otherwise not applicable to this case.
No, the RERA will also be applicable.
In this
8 acres above, 8 kathas above. All projects which are 8 kathas above, RERA has to be compulsorily complied with.
All right. Yes, RERA rules.
Now, the rule kindly comes to rule 16.
Yes, longish rule.
But I shall only place the shorter version.
Yes.
Yes. Lord kindly comes to yes. Lord E. Subrule 1 E. M.
E.
M.
M. Yes.
This is the documents which the promoters are required to upload. M says authenticated copy of occupancy certificate and completion certificate, including application.
RERA Act has both. There is no difficulty.
It's not about RERA Act because occupancy certificate is not issued by RERA Act.
Occupancy certificate is defined in RERA Act.
Defined, but
must be a provision
issued by the municipality. There is no provision under the RERA Act to issue occupancy certificate because what RERA does is to see
yes,
whether
issued by the competent authority permitted.
That is always by the municipal authority.
Yes.
Because that has to comply with because sanitation, those habitable, whether the building is habitable or not.
Yes.
So this is one thing. Kindly comes kindly comes to rule 4 also.
But then both have to be furnished by the promoters.
Yes, I have to. These occupancy certificates are the period since when they are in occupation. And thereafter, as a whole, when the project gets completed, I get a completion certificate. Now, after completion of the project, both I have to upload. That is my duty, part of my duty.
All right. 4.
Lord 4 kindly comes to 4.1. Here your lordship will find only use of completion certificate is there. Occupancy certificate is not required. This is just to show two are differently used in different places. Not that relevant, just to show your lordship.
Both are different concepts, definitely. There is no doubt on that.
Now, Lord, with respect to Annexure A in council passed as a Rule 9, part of Rule 9, Annexure A, Lord, is a format for agreement for sale. There at clause 5, Lordship kindly got it, Lord? Is after Lord Form O. It is after Form O. Annexure A is after Form O. This is a statutory format, Lord. All RERA projects have to comply with this. My Lord has kindly got it, Lord. Clause 5, time is essence.
Clause 5.
Clause 5 of that particular agreement, time is essence.
Yes.
Time is essence. Time is of essence for the promoter as well as the allottee. The promoter shall abide by the time schedule for completing the project and hand over the apartment plot such as allottee common areas to the association of the allottees after receiving the occupancy certificate or the completion certificate or both, as the case may be. So, in a situation where there is only a single building, there is no question of occupancy certificate to be handed out. So, the Act provides for both situations, as it was falling from your lordship. it might be a situation where it's a single story building. So, my lord, there's no question of occupancy certificate, directly, my lord, or completion certificate, or both. Lord, remaining are also there. I'm not bothering your lordship for that. Kindly now, my lord, comes to the rules.
Municipal.
My municipal. Continue. Lord, kindly comes to first rule 16. Lord, only these things will take some time, Lord. Thereafter, I'll try to shorten my argument.
No difficulty, but we do. Where are the rules? Rules নেই এখানে শুধু একটা
Bengal
আছে।
rules think that.
West
Lord, may I hand up to your lordship, Lord?
West Bengal.
AMC rules.
What rules?
Lord, Bengal municipal rules.
Bengal municipal rules. Rules নেই।
2007 আনতে।
Rules এর বই আছে?
But I have a copy, Lord, if your lordship wants.
এটা আনলে একটা
Dijosha বসে আছে।
ABCD করে এবার আমাদের একটা
My lord, I have the latest version of the rules. Okay, along with 16 also kind of 34 also.
Yes, 34 I'll place. 34 I'll place.
এটা আনিয়ে নেবেন দেখুন ওই একই বইয়ের নাম এই লেটেস্টই আনতে হবে হ্যাঁ ওখানে ইনভেরিয়েবলি 2025 থাকবে না আমাদের লাইব্রেরিতে তাহলে আনাতে বলুন
Fine.
Yes, rule 16.
Rule 16I. These duties and responsibilities of architect and licensed building surveyor. So this says they shall submit the completion certificate and completion plan immediately after the work is completed. So, Lord, here the rule is with respect to only completion certificate, because after completion plan is issued. Because the project, Lord, initially I apply for a sanction plan. The sanction plan is granted. I start commencement of work as per the sanction plan.
Yes.
During the commencement of the work, there might be some deviation. Lord, a revised plan might be required. When I file the final plan, that's the completion plan. Thereafter, I apply for my completion certificate. Upon inspection being held, Lord, completion certificates are issued. This is how, Lord, for a single structure, single story.
Up to rule 34.
Now, Lord, Lord, before going to rule 34, kindly, Lord, also sees rule 17, F and K. Here also your lordship will find only usage of the word completion certificate. F and K.
Don't use them together. Yes. What does F say?
Lord,
he shall be
he
responsible.
shall be responsible for full quality control of materials and workmanship at site and carry out necessary tests on material use such as such and such. No completion certificate will be issued unless copies of such test report. No, these are on parameters. Is only to indicate, Lord, that the statute is using these two words separately. Lord,
Yes,
your lordship need not, Lord, get into
after
this.
the entire thing is over then.
Completion. Kindly come to, Lord, rule 21.
Yes.
Lord, rule 21 proviso is important. Provided
না বলুন যে 25 এর একটা বেরিয়েছে কমন ল হাউসে ওটাকে আনে নিতে Yes.
Provided that in case of a provisional sanction, the applicant shall furnish a statement of activity he is unable to produce the license or permission as required. The provisional sanction shall be at his own risk and cost and shall not be made final. And the occupancy certificate under 2122, Lord, as I indicated, that's your lordship's answer, shall not be issued in respect of the use which is affected by, not these are the restrictions. So, Lord, occupancy certificate is basically issued on the basis of 2122. Lord, that permission that I was trying to impress upon your lordship. Now, Lord, kindly comes to rule 23. A sanction plan, may I, Lord? A sanction plan to erect a building accorded under
this rule?
No, rule 23.
23 আছে, yes. Yes.
A sanction to erect a building accorded under these rules shall be valid for 3 years from the date on which it is sanctioned and may be renewed thereafter for a further period of 2 years on payment in cash such and such need not. A building plan may be revalidated for a further period of years only in case a building has been partly completed and occupancy certificate in terms of Rule 34 has been issued, as well as on production of previous sanction plan, the completion certificate and receipt of such and such required to be paid from time to time. So, Lord, first the occupancy certificate. Based on that, the completion certificate. Now, Lord, kindly comes to, I'm sorry. Now, my lord, kindly comes to Rule 28.
Yes.
Sub-Rule 2. From the date of commencement up to the date of issue of occupancy certificate, the applicant shall keep at the site copies of one set of plans and specifications and any provisions thereof as returned to him by the municipal authority along with such and shall also exhibit at the conspicuous place the number of premises, the name of architect such and such. Lord, this also demonstrates, because once the completion certificate is issued, the project is completed for with respect and chapter is closed for KMC or the municipal authorities. There is no requirement for demonstration of these specifications. But after occupancy certificate is issued, these are required. The reason is building is incomplete, the project is incomplete. It's only a permission to occupy, nothing more than that. Now, my lord, kindly comes to Rule 34. And before Rule 34, Lord, your Lordship was asking me a question, Lord, that notice of completion. That your Lordship would file on Rule 33. Within 1 month from the completion of the erection of a building and execution of work, the owner of the building shall submit a copy of notice of completion such and such 212.
This speaks about completion of the building.
Yes. This no, completion of work. This I am showing to your Lordship only for the reason that there was a permission until permission granted. Kindly recalls, Lord.
This says within 1 month after the completion of the erection of a building or execution of any work, the owner of the building shall submit a notice.
Erection of a building or completion of a work. So, Lord, when I'm talking about a project, Lord, completion of one building out of 10 is also completion of a work. So, Lord, both has to be, Lord, read in consonants. Lord, that's why, Lord, completion certificate, occupancy certificate, or both. Your Lordship recalls that, Lord, language, or both. Now, my Lord, kindly comes to 34.
Yes.
Within 15 days of receipt of the notice of completion of building or work, again, the Board of Councillors or the authorized representative in this behalf shall inspect the building or work and shall satisfy itself erection of the building and execution of work has been done in accordance with the sanction plan. Within 15 days, such and such, Board of Councillors shall, if it is satisfied that the building or the work is complete in accordance with the sanction plan, issue an occupancy certificate in Form H, provided that such certificate shall not be issued in the case of a building or work provisionally was given unless the applicant produces before the chairman the license or permission required or sanction construction building. Provided further that the occupancy certificate shall be issued only after all the extra material, sand such and such has been removed and their satisfaction of building. After due verification, one set of the building plan shall be returned to the applicant with the endorsement of the approved completion plan under the signature of such and such. The Board of Councillors may, upon written note, thereafter it goes on.
There is an indication probably in the proviso in your favor also, the first one, that the occupancy certificate shall not be issued in the case of a building or any work. Yes, unless the applicant produces before the chairman the license or permission required for sanction for construction of building. So he's not required to prove a completion certificate, but only the sanction. Sanction means the commencement, pre-commencement.
I'm grateful.
So therefore, if it was said that completion certificate was also required, then he might have
I'm grateful.
already.
No, and that is more of a reason why Milord two Milord words have been
Concepts,
used
yes.
separately.
No, two concepts are separate that you can understand. Question is whether occupancy certificate can precede a completion certificate. That is the question.
That also
Concepts are different. There is no doubt on that.
That also I've Milord tried and showed to your lordship. Milord, because if the only reason is if completion certificate is the ultimate one. So Milord, if partial or Milord occupancy certificate was dependent upon completion certificate, there was no requirement for Milord issuance of a.
And partial occupancy certificate is also there.
Yes. Milord, partial occupancy certificate again in case of Milord when there is a single building. Milord, 2 floors are habitable. Milord, the corporation is satisfied that
if that is possible, then that also does. Obviously, the completion was not there.
Yes.
There was no completion certificate. So if that provision is there, there can be a partial occupancy certificate. Then also completion certificate is not required. Obviously, if half a building is completed,
the entire purpose is Milord, so that for the completion certificate, the interregnum work does not stall, or Milord, the promoters do not have to wait Milord for Milord, the money to come in. Basically that. Now, Milord, kindly comes to 35 to 37. Delay in issue of occupancy certificate. In case where within a period of 30 days from the receipt of notice of completion, the Board of Councillors fails to issue
everything else follows.
Yeah.
Nothing important.
Prohibition, Lord, thereafter work subsequent.
Did not present.
Lord, the 37 is important.
Why?
Work subsequent to issue of occupancy certificate, if any erection, re-erection, such and such, fresh notice. Lord, that's already there.
No, that is different.
Consequential.
That is the addition, alteration, or re-erection.
Consequential. Now, Lord, only one
34 and 34A also probably gives something to you. 34B is blockwise occupancy certificate also.
That Lord, yes. For building proposal containing more than one building, Lord, that's exactly what my case is. That's exactly what my case is.
So there are several provisions of occupation certificate which can precede completion certificate. Completion of the project as opposed to part of the building or a part of the one block.
I'm grateful.
We'll continue from here. এই বইটা ওনাকে ফেরত দিয়ে দিন আর একটা আনিয়ে নিন
The written notes are right now because in this.
I think that it is better that you take back.
I'll take back.
It may something
I will
maybe.
incorporate this point.
I also think so. I'm not recording that you are filing your written notes.
My lord, may I item number 18?
1 minute. Hard in part for further hearing on May 16, 2025. Yes, sorry. Yes.
My lord, I have instruction not to appear in this.
Which matter?
In 18 and 19.
18 and
My lord, my
we will not call because you are rising. You have instruction not to appear.
Not to proceed with the matter anymore.
Then definitely it will be called on. Yes. Yes, come. 18, 19. Yes. You are for the petitioner.
My lord, for the applicants in both the matters, my lord.
18, 19, you have. Acha.
My lord, these both are the assigned matters, my lord. Repeat the instruction in WhatsApp, my lord.
Learned counsel appearing for the appellant in both the matters submits that the appellants do not want to the appellants in both the matters do not want to proceed with the appeals. Push up the a printout of the this is a WhatsApp message or what?
My lord.
A printout of a WhatsApp message in that regard, but it says do not proceed right now.
My lord.
Then in present situation I can't proceed. A printout of the WhatsApp message by the appellants to their learned counsel in that regard, filed today in court, be kept on record. Push up accordingly. FMA 91 of 1991 এটা থাকবে record. FMA 91 of 1991 and FMA 92 of 1991 are dismissed for non-prosecution without an orders to cost.
Only one thing, Lord, I was led by Mr. Siddhartha Banerjee, Lord.
He is in the court proceedings.
He was virtually present.
Then let's solve it. He was there.
Yes, he was.
Are you sure he was there?
I was told, Lord, very well, Lord. Let's
Chilo কি?
Then let.
Don't take the risk. Tomorrow some FIR will come, his name there to have been doing something in somewhere. And this was the example given by my senior. That he will be caught somewhere and there will be an FIR and your name will be recorded in order of this court. Don't take the risk. Then it will be a double FIR. Anyway, don't put his name in.